Hi, good morning, everyone. So, where all we have covered till, okay, we have covered till, okay, fine. So, let's continue with Article 19 of the Constitution. We have discussed till now about Article 19(1)(a) and 19(1)(b). 19(1)(a) that provides the right to freedom of speech and expression can be reasonably restricted on the basis of the grounds that have been provided in Article 19(2). We have already discussed the grounds that have been provided in Article 19(2), including the contempt of court, defamation, etc. Then Article 19(1)(b) provides the right to assemble peacefully and without arms, and that can be restricted on the basis of the grounds that have been provided in Article 19(3) of the Indian Constitution. I have already discussed with you that right to strike is not a fundamental right. It is only a statutory right provided by the Industrial Disputes Act. Similarly, we have also discussed about the organization of bunds called by political parties and the Supreme Court's view on the same matter. Now, Article 19(1)(c) of the Indian Constitution provides all the Indian citizens right of freedom to form associations, unions, and cooperatives. And this right can also be subjected to reasonable restrictions mentioned in Article 19(4) of the Indian Constitution. What we need to be aware of is that 97th Constitutional Amendment Act changed the text of Article 19(1)(c) of the Constitution, where the word cooperatives has also been added to Article 19(1)(c) now. Now, what exactly is the meaning and what is the objective of providing right to form associations, unions, or cooperatives under Article 19(1)(c)? The idea is that the citizens should be able to organize themselves politically as a group, should be able to organize themselves and be able to express their views and opinions as a group is what is the objective of Article 19(1)(c) of the Indian Constitution. And as I just suggested, that Article 19(1)(c) can be restricted on the basis of the grounds provided in Article 19(4). So let's quickly have a look at Article 19(1)(c) and 19(4) of the Indian Constitution to understand this concept further. So Article 19(1)(c), again just repeating, it says that all the citizens have the right to form associations or unions or cooperative societies. This right is essentially providing a freedom to the Indian citizens to politically organize themselves. But just like any other freedoms that have been provided in under Article 19, this also is not an absolute freedom that has been provided, because it can be restricted on the basis of the grounds of sovereignty and integrity of India, on the grounds of public order, or on the grounds of morality. What you need to keep in mind again and again, what I am pointing out is that 97th Constitutional Amendment Act has introduced the word cooperatives as well now under this particular fundamental right. In fact, 97th Constitutional Amendment Act changed the text of the directive principles of state policy as well. Article 43B was introduced into the Indian Constitution, and Part 9B was also introduced that provided the various principles and standards that should be adhered to while the formation of the cooperative societies takes place. Even though in a recent judgment of the Supreme Court of India, which was pronounced last year in Rajendra N. Shah versus Union of India, Supreme Court has struck down several parts of Part 9B of the Indian Constitution for not following the adequate procedure under Article 368. We have already discussed that proviso to Article 368 Clause 2 provides those particular matters which can be amended only when there is a ratification from at least half of the state legislatures. And one of those is that whenever there is anything which is going to impact the distribution of the powers between the center and the states, or the union and the states with respect to legislative powers. Now, cooperatives is a state subject, except multi-state cooperative societies, which is a concurrent list subject. So when we talk about the cooperatives in India, that is a state subject. So no law can be made by the union on the cooperative subjects. And when Part 9b was introduced into the Indian Constitution, which basically lays down the guidelines that should be followed by the state with respect to the functioning of the cooperative societies under their jurisdiction, then in that case, Part 9b was being violative of the procedural inadequacies. Why? Because जब हमने लोकल सेल्फ गवर्नमेंट के ऊपर 73rd या 74th कॉन्स्टिट्यूशनल अमेंडमेंट एक्ट इनैक्ट किया, हम तब भी स्टेट के सब्जेक्ट में इंटरफियर कर रहे थे. बट एट दैट पॉइंट ऑफ टाइम, after the constitutional amendment bill had been passed by the parliament, it was sent to the state legislatures for their ratification. But in case of 97th constitutional amendment act, despite the fact that it was interfering in a matter which is purely the subject of the states, which is cooperative societies, how can the union be providing directions by passing a constitutional amendment act and stating that these are the guidelines that should be followed by the state in forming the cooperative societies? It would be violative of the principle of federalism if such a bill would not be ratified by the state legislatures concerned. And the Supreme Court held that because of procedural inadequacy, because of not following the proper procedure mentioned in the Indian Constitution, Part 9b of the Indian Constitution is violative of the basic structure of the Constitution, is ultra vires of the Indian Constitution. Why? Because the center or the parliament enacted a provision in the Indian Constitution that in some ways impinges upon the powers of the state on a state subject without seeking the permission of the state legislatures concerned. If the parliament would have sent this bill to the state legislatures for their ratification, and at least half of the state legislatures had provided their approval to such a bill, then it would not have been a problem. But because there was this procedural deficiency in Part 9b of the Indian Constitution, Supreme Court has struck it down. Right? So we will discuss about cooperatives later on as well, but I just wanted to give you an idea of that. So just write down a very short paragraph related to Article 19(1)(c), where you can state that Article 19(1)(c) provides Indian citizens the freedom. Article 19(1)(c) provides Indian citizens the freedom to form associations or unions, provides Indian citizens the freedom to form associations or unions or cooperative societies. Full stop. This provision recognizes the right of Indians. This provision recognizes the right of Indian citizens to organize themselves politically or otherwise. To organize themselves politically or otherwise. Full stop. Just like any other freedom, this freedom is also not absolute. Just like any other freedom, this freedom is also not absolute and can be subjected to reasonable restrictions on the grounds of sovereignty and integrity of India, SNI of India, public order, can be reasonably restricted on the grounds of sovereignty and integrity of India, public order, and morality. Full stop. The word cooperative society was introduced in this provision. The word cooperative society was introduced in this provision by the 97th Constitutional Amendment Act. by the 97th Constitutional Amendment Act 2011. Okay, so this is another right which has been provided to all the Indian citizens, and this is essentially a right to be able to politically or otherwise organize themselves in form of some kind of a group, in form of some kind of an association, in form of some kind of a body, where they would therefore be able to express their views and opinions collectively. तो ये एक कलेक्टिव राइट की तरह भी एमर्ज करता है, क्योंकि इंडिविजुअली आप इसको एक्सरसाइज नहीं कर पाओगे प्रॉपरली, but when you collectively form an association, organization, or any kind of an entity where you are trying to express your views and opinions through that particular entity or organization, then Article 19(1)(c) comes in handy. Now, Article 19(1)(d) and 19(1)(e) of the Indian Constitution are very closely related to each other. Article 19(1)(e) and 19(1)(d). So 19(1)(d) provides all the Indian citizens the freedom to move freely throughout the territory of India. So this is right to movement throughout the territory of India, right? Right to move freely throughout the territory of India. And we have 19(1)(e) of the Indian Constitution that provides the right to reside in any part of India. So right to movement and right to reside. Of course, both of these are very closely related to each other. If you have right to move throughout the territory of India and to go to any part of India, that also means that since we have single citizenship in India, we do not have dual citizenship. You can not only move throughout the territory of India, but you can choose to settle down and reside in any part of territory of India, considering the fact that entire country is one. So both of these rights are closely related to each other. One that provides right to movement throughout the territory of India, and second one, right to reside in any part of territory of India. Of course, both of these rights are also not absolute rights and can be subjected to reasonable restrictions on the basis of the grounds that have been provided in Article 19(5). क्योंकि ये दोनों इतने क्लोजली रिलेटेड हैं, इन दोनों के ऊपर रिस्ट्रिक्शन जो है वो 19(5) के बेसिस के ऊपर लगाई जा सकती हैं. The grounds that have been provided in 19(5) for imposing reasonable restrictions on the right to movement as well as right to reside throughout the territory of India are as follows. One ground that has been provided in 19(5) is essentially the ground of the interest of scheduled tribes. Sorry, the interest of general public. Of course, this is a very broad term and it can be interpreted very broadly, but if we just look at the basic meaning of the term in the interest of general public, if there is any movement of a person which is going to hurt the general public interest, then that can be a ground for restricting the freedom of movement. So during COVID-19, when the government imposed lockdown across the country, and when people were not allowed to move out of their homes and move from one particular state to another state, that was a reasonable restriction that could be imposed in the interest of general public. So therefore, the government invoked the Epidemic Diseases Act and the National Disaster Management Act, and these two laws impose restrictions on the movement of people during the COVID-19 pandemic, and this was done in the general interest of the public, right? So not only your right to movement was restricted, but in a way one could say that one's right to reside throughout the territory of India was also restricted during the COVID-19 pandemic by invoking these laws. Are these laws constitutional, or were these restrictions constitutional? The answer, of course, is yes, because it was done on the grounds of interest of general public. And the second ground that has been provided is even more interesting, which is for the protection of the interest of the scheduled tribes. So in some parts of India, we have, especially in northeastern states, we have something which is called as the inner line permit. Earlier, this used to exist in Ladakh as well, but now very recently, inner line permit restrictions have been taken away from Ladakh because the Ladakh administration wants to open up entire Ladakh to the tourist inflow, and therefore they have removed those particular restrictions. But inner line permit exists in some states of India. For example, if you want to travel to Nagaland, or if you want to travel to Arunachal Pradesh, then you would need to seek permission from the government before entering this state. This has been done in order to protect the interest of the scheduled tribes, those who are resident in these particular areas जहां पे ये inner line permit applicable है. The idea is that these tribals have always lived in an isolated manner, and if you expose them to the mainstream civilization in an unrestricted and an uninhibited manner, it may lead to a number of drastic changes in their society that may not be conducive for them. Therefore, inner line permit that is provided in as a restriction to move and to reside in some parts of India has been done in the interest of the scheduled tribes. So if you, let's say, want to buy a property in Nagaland as an Indian citizen, then you would not be able to do so, because there are restrictions that have been imposed on us as Indian citizens. You cannot say that I have right to reside throughout any part of territory of India. It would not be allowed because inner line permit is applicable there. You would have read in the newspapers about a foreigner trying to enter into the Sentinelese Island in Andaman and Nicobar. You know, in the Andaman and Nicobar group of islands, there is an island called as the Sentinelese Island as well, where the Sentinelese tribes stay. And the level of restrictions that have been imposed with respect to entry into Sentinelese Island is such that even the Indian government and the Indian administration does not venture into that area. In some of these islands, in Andaman and Nicobar and in Lakshadweep, the government, when it conducts the census, it does not send its people to conduct the census. Rather, what the government does is that they take some ration and some items, they put it on the shore or on the coast, and then on the basis of the images and the videos that they capture, they make an estimate of the number of people, those who may be living on the Sentinelese Island. The reason for that is because these people have not been exposed to the viruses and the bacteria that you and I are carrying on our body right now, which we have become immune to. Our immune system has become immune to a large number of viruses, large number of bacteria, etc. And our body is not affected by them. But many of these tribal groups are not exposed to these viruses, bacteria, because that is how they have been living for thousands of years. They have not been in touch with the mainstream of the society. If we were to expose them today to ourselves, then there is a possibility that these people may go extinct. So in order to protect these scheduled tribes, indigenous people, we have restricted the movement as well as the right to reside in some of these areas of the country. Some people may say that isn't it counterproductive to national integrity and unity? Maybe so, but then you have to look at the other side of the story as well, which is in order to protect the interests of the scheduled tribes, we have imposed these particular restrictions under the Indian Constitution, right? So, right to movement and right to reside are also provided under Indian Constitution. Again, not absolute freedoms. One, they can be restricted on the grounds of the interest of general public, and second, in the interest of the protection of the scheduled tribes in the country. So inner line permit as a law that restricts access to some parts of the country is constitutionally valid because it is sanctioned by Article 19(5). Similarly, when the movement was restricted during the COVID-19 lockdown throughout the territory of India, that was also a reasonable restriction, that was also a constitutionally valid restriction, because that was imposed on the basis of the grounds that have been provided in 1905, that is in the interest of general public. Is that clear to everyone? Right, so please write down quickly. Article 19(5) provides Indian citizens, Article 19(5) provides Indian citizens with the right to move freely throughout the territory of India, with the right to move freely throughout the territory of India, whereas, full stop, whereas Article 19(1)(e), whereas Article 19(1)(e), 19(1)(d) लिखना था, हाँ 19(5) लिखवा दिया मैंने गलती से, सॉरी, 19(1)(d) and 19(1)(e), हाँ, whereas 19(1)(e) provides Indian citizens to reside and settle, provides Indian citizens the right to, provides Indian citizens the right to reside and settle in any part of territory of India. Provides Indian citizens the right to reside and settle in any part of territory of India. Full stop. Please write down. During COVID-19 pandemic, restrictions imposed on movement, were sanctioned by Article 19(5), as it allows the state to impose reasonable restrictions, on the grounds of A, interest of general public, and B, protection of interests of scheduled tribes. Now please write down further. 19(1)(e) can also be restricted. 19(1)(e) can also be restricted on the above mentioned grounds, and therefore restrictions imposed by inner line permit regime are also constitutional, as they seek to protect the interests of scheduled tribes. Is that clear to everyone? Right? So this is about Article 19(1)(d) and 19(1)(e) that can be restricted on the basis of the grounds that have been provided in 19(5). Fairly simple and straightforward kind of a provision. Now, 19(1)(g), 19(1)(f) was removed from the Indian Constitution by the 44th Constitutional Amendment Act that provided Indians the right to freedom to acquire, dispose of, and enjoy property. We will discuss about right to property when we will move on to discuss about Article 31A, B, C, and when we will discuss about the directive principles of state policy. But for now, we will focus on Article 19(1)(g) of the Indian Constitution. So Article 19(1)(g) also provides a freedom to the Indian citizens, and this time the freedom that has been provided to the Indian citizens is the freedom to carry out any trade, business, occupation, or profession. So Article 19(1)(g) provides Indian citizens the right to carry out any trade, business, occupation, or profession of their choice. Of course, this right is also subject to reasonable restrictions, and it has been subject to reasonable restrictions provided under Article 19(6) of the Constitution. Now, let's say if some person says that I want to become a doctor. Great, you become a doctor. No one is denying you that opportunity. But someone says that no, I don't want an MBBS degree. I don't want any certificate from Medical Council of India, but I will exercise and practice my profession as a doctor. I will prescribe medicines to people. I will treat people. I will conduct surgeries on them. Then that will not be allowed. The reason for that is because if you read Article 19(6), it states that technical and professional qualifications may be imposed by the state to carry out some kind of profession or occupation. If a person wants to carry out the profession of a doctor, then you need to get a technical and a professional qualification from the Medical Council of India. If you want to carry out your profession as a lawyer, then you need to get the technical and professional qualification from the Bar Council of India. If you want to carry out your profession and business in some other areas as well, where some professional qualifications have been prescribed, then you need to obtain them before you can qualify to be called as a professional and to be able to exercise your powers and to be able to carry out that particular profession. So Article 19(1)(g) is a very important provision because it is providing people right to carry out trade, profession, business, occupation under the Indian Constitution, but this is also subject to reasonable restrictions mentioned in Article 19(6). Now, there is this one case that came up in front of Supreme Court of India, which is also called as the McDowell's case. Now, all of you would be knowing about McDowell's number 1, right? So, now this McDowell's case, not that I suggest to you that you should be consuming McDowell's number 1, not only because, you know, it is not conducive for you people when you're preparing for the civil service exam, but also because it is a very bad alcohol. Okay, so you could go for something which is better in quality, right? So, poor, cheap quality alcohol. Okay, so anyway, so McDowell's case came up in front of Supreme Court, and now see, prohibition has been imposed in some states. We know that Gujarat is a dry state. You know, prohibition has been imposed on the manufacturing, on the trade, on the selling, as well as of the consumption of liquor. Now, in that particular case, the question is that what about those people, those who have the profession or those who have the business or the occupation of producing liquor, manufacturing liquor? What about them? Would that not be a violation of their fundamental right? So that was the question that came up in front of Supreme Court of India. So first and foremost, the restrictions or prohibition that were imposed in a particular state or on the regulation of the business of the production or the manufacturing of the liquor was justified by the state on the grounds of Article 47 of the Indian Constitution. So if you read 47, 46, sorry, not 47, 46. 47, sorry. Yes, 47. So Article 47, if you read, it states that the state shall regard the raising of the level of the nutrition and the standard of the living of its people and improvement of public health as among its primary duties. And in particular, the state shall endeavor to bring about prohibition of consumption except for medicinal purposes. अब वो अलग बात है कि आपकी मेडिसिन यही है, तो that is another thing, but it says that except for medicinal purposes of intoxicating drinks and of drugs which are injurious to health. So the state went to the court and said that we have imposed prohibition on liquor on the grounds of Article 47 of the Indian Constitution, which casts a duty upon the state to prohibit the consumption of intoxicating drinks and drugs and their consumption in the society. But then the petitioner made the contention that, sir, Article 47 is a directive principle of state policy. Directive principles of state policy are not enforceable like fundamental rights. They are non-enforceable in nature. They are merely directions provided to the state that they should follow in making their policy. Directive principles of state policy are non-enforceable in nature. तो आप इनको वैसे भी एक लीगल फोर्स की तरह एनफोर्स नहीं कर सकते. और हाउ कैन यू से दैट वी विल वायलेट आर्टिकल 19(1)(g) in the favor of Article 47, which is a directive principle of state policy, whereas Article 19(1)(g) is a fundamental right that is enforceable. तो जो चीज enforceable है, आप उसके ऊपर इंपॉर्टेंस दे रहे हो 19 of a directive principle of state policy. So in this case, the court stated that, see, when there are two provisions which have been mentioned in the Indian Constitution, Constitution makers must have written it with some application of mind. It must not have been written in an arbitrary manner or in a random manner. And even though both these provisions may come into conflict with each other, it is the duty of the courts to provide such an interpretation to both the provisions simultaneously that they do not in any way compromise the other one. So basically the court is saying that we understand that both of these are conflicting provisions. जो शराब बनाने वाला है वो कह रहा है, सर I have 19(1)(g) as the fundamental right of trade, profession, business, occupation. Whereas state on the other hand is contending that we have Article 47 of the Indian Constitution, which is non-enforceable in nature. So therefore we are making this law, we are doing this under Article 47. This person is saying that no, my Article 19(1)(g) is getting violated. State's duty should be to enforce 19(1)(g), not Article 47. So court states that, see, both the provisions are there and they are in conflict with each other at times. But it does not mean that we should hold one over the other. We should try to give such an interpretation to both the provisions simultaneously that we don't need to compromise on one in the interest of the other. So, because in case of restriction being imposed on the manufacture of liquor or on the business of manufacturing or the trade of liquor is only being done in a very limited manner, one cannot say that Article 19(1)(g) is being violated completely. In the interest of Article 47, हम दोनों को ऐसी रीडिंग दे सकते हैं कि थोड़ा सा इसको रिस्ट्रिक्ट कर दिया जाएगा इसकी इंप्लीमेंटेशन के लिए. That is what all we are saying. Plus on top of that, the state is right in imposing such restrictions because it can be imposed on the basis of the grounds provided in 19(6). So if you read 19(6) of the Indian Constitution, you will find the grounds that can be imposed on right to freedom of trade, profession, business or occupation, where it says that nothing in subclause G of the said subclause shall affect the operation of any existing law as far as it imposes or prevent the state from making any law imposing in the interest of general public. So the state justifies that we are imposing a reasonable restriction on this particular right on the grounds of 19(6), that allows us to impose reasonable restriction in the interest of general public. And it is in the interest of general public that we are imposing prohibition in this part of the territory of India, and that can be done on the basis that Article 19(1)(g) itself is not a fundamental right and can be restricted on the basis of the grounds provided in the interest of general public. Apart from that, if you read Article 19(6) further, it says that nothing in the said subclause, and in particular, nothing in the said subclause shall affect the operation of any existing law insofar as it relates to or prevent the state from making any law relating to. And then it says two things. State can make laws with respect to two things so as to restrict one's right under Article 19(1)(g). One is that the state can make a law where it may provide professional or technical qualifications necessary for practicing any profession or carrying on any occupation, trade or business. So state can make a law and can provide professional or technical qualifications that are required to be satisfied by an individual before carrying out any trade or profession. Some professional or technical qualifications may be required, और ये reasonable restrictions में आएगा on the right to freedom of trade, profession and occupation. तो एक तो ground है in the interest of general public, जिसके बेसिस के ऊपर हमने समझा कि ये किस तरीके से प्रोहिबिशन इंपोज किया जाता है लिकर की कंजम्पशन या लिकर की मैन्युफैक्चरिंग या लिकर के ट्रेड के ऊपर कुछ स्टेट्स में या कुछ एरियाज में. सेकेंड इज दैट इन द इंटरेस्ट ऑफ in order to ensure that certain professional or technical qualifications may be required for some kind of a trade or profession, then also state can impose restriction. And then the third is the state may also impose restrictions on right to freedom, trade, profession, business or occupation by making a law and stating that citizens will be partially or fully excluded from carrying out that particular trade, business, profession or occupation. So if you read the subclause 2 there, it says the carrying on by the state by or by a corporation owned or controlled by the state of any trade, business, industry or service, whether to the exclusion, complete or partial of citizens or otherwise. So basically, state can also make a law, and this law can restrict some trade, business, occupations, etc. only to the state or state controlled corporation or entity. तो जब गवर्नमेंट ये बोलती है कि न्यूक्लियर पावर प्रोड्यूस करने की राइट्स केवल और केवल स्टेट के पास हैं या केवल स्टेट ओन्ड एजेंसीज के पास है, ओनली बार्क और ओनली वॉट एवर organization will be carrying on research in nuclear energy. Only ISRO will be involved in space research and sending rockets to the space. No other private agency would be able to do so. They are doing so because of Article 19(6) that allows the state to restrict certain trade, businesses, etc. only for the state. And in this, state may also fully or partially exclude citizens from such a trade, may fully or partially exclude citizens from such a trade, business, profession or occupation. Okay, so there are so many areas in which private sector is not allowed to venture into, and that is because of Article 19(6) that allows the state to restrict certain trade, profession and business only to the state, or as it states, state owned corporation or companies or entities that are controlled by the state. In those industries, in those services, in those business, government can partially or even fully exclude the citizens. So earlier, the only telecom services that were available in India were state controlled telecom services provided by BSNL and MTNL. Then after that, the state opened up the telecom sector for private sector as well, and then the Airtels and the Vodafone and the Ideas of the world also entered into telecom business. Earlier, otherwise, this particular business, industry and trade was completely restricted only to the state or state controlled entities or state owned entities, and where citizens had been fully excluded. Exclusion of citizens can be full or can be partial in nature. Right? So what we understand from this is that Article 19(1)(g) also is not an absolute, right? It can be restricted on the basis of the grounds of, first and foremost, the interest of general public, and secondly, it can also be restricted on the interests, on the grounds of where the state may provide professional or technical qualifications for carrying out certain trade, business, profession or occupation, or the state can also restrict some trade, business, profession or occupation to be only performed by the state, either to the full or the partial exclusion of the citizens of India. So therefore, this is also not a fully absolute fundamental right that has been provided to the Indian citizens. Is that clear to everyone? Right? So please quickly write down related to Article 19(1)(g). Article 19(1)(g) provides right to Indian citizens, to carry out any occupation, trade or business, or to practice any profession, full stop. But this right is not absolute, and can be restricted, by the state. But this right is not absolute and can be restricted by the state on the grounds of interest of general public. Therefore, liquor prohibition imposed in certain areas can be justified on the basis of this provision. Full stop. Next line. Further, comma, the state may also prescribe technical or professional qualifications required for carrying out any trade, occupation or business. Therefore, desirability of possessing professional qualification to practice as a doctor, desirability of possessing professional qualification to practice as a doctor is sanctioned by this provision. Full stop. And last, write down, also the state may fully or partially exclude the citizens from certain trade, business or industry, and even allow state monopoly in such cases. Okay? So this is what we need to keep in mind when we talk about Article 19(1)(g) of the Indian Constitution. But now see, we have discussed till now that under all the restrictions or the grounds that have been provided for imposing restrictions on the various freedoms from 19(1)(a) to 19(1)(g), reasonable restrictions can be imposed by the state. But the question remains that what is the meaning of the term reasonable restrictions? Reasonable restriction का मतलब क्या है? Reasonable is a very subjective term. What may be a reasonable restriction to you may not be a reasonable restriction for me. Reasonability तो बहुत सब्जेक्टिव बात है कि क्या ये रिस्ट्रिक्शन रीजनेबल है कि नहीं है. If a child is, let's say if a young boy is going out of home, parents tell him that you should return home by 8 o'clock. Is that reasonable? The other parents of other child say that you should return home by 10 o'clock. Is that reasonable? Who defines what is reasonable? So in India, courts have taken the responsibility of defining whether a restriction that has been imposed by the state on any of the freedoms that have been provided in Article 19 is reasonable or not. Otherwise, if restrictions would not be reasonable, पहली बात तो reasonable लिखने का हम पहले ही मतलब समझ चुके हैं कि reasonable इसलिए लिखा गया जिससे कि स्टेट की पावर को आप लिमिट कर सकें, कि वो कोई भी रिस्ट्रिक्शन ना लगा दे, वो केवल वही रिस्ट्रिक्शंस लगाए. It should only impose those restrictions which are reasonable in nature. But then the question is, who will decide reasonability? The question of reasonability would be decided by the courts. So if you think that there is a law that has been made by the state which is imposing a restriction on your freedom of speech and expression in an unreasonable manner, then you can approach the court and say that this is an unreasonable restriction. And if you can prove the unreasonability, the arbitrary nature of the restriction, then you may have your way and the court may be forced to strike down such a law made by the state. I have already discussed with you about the case of Shreya Singhal versus Union of India, where the law said that in case any communication sent over the internet or any computer device in any way annoys a person or causes inconvenience. Now see, this is unreasonable. If something is causing annoyance to that person And if you are restricting my freedom of speech and expression for that, that is that person's problem, not my problem. Right? So inconvenience or annoyance are unreasonable restrictions that are being imposed. And neither of these are also mentioned in 19(2) of the Indian Constitution that can be provided as a ground for imposing restrictions on the freedom of speech and expression. So the Supreme Court has laid down certain guidelines and rules with respect to what is the meaning of the term reasonable. So let's have a look at that particular aspect once. What do you understand by reasonability? वो पीपीटी नहीं अपलोड किया उन्होंने? यहां कर दिए. बोले यार यहाँ पे कर दिया करें ना, उस पे करेंगे, अब फिर मैं इससे मूव करूं, एंड आई डोंट अंडरस्टैंड ऑल दिस. एनीवे उन्हें बोलना ब्रेक के अंदर करें जो भी करना है. बेसिक सा एक चीज है यार, एक प्रोसेस है, एक सिंपल प्रोसेस है. अगर इतना नहीं समझ पा रहे हैं तो मतलब बड़ा मुश्किल है समझना ना कोई भी चीज. फिर यहाँ पे नहीं है सर, वो यहाँ पे अपलोड किया उन भाई साहब ने. अब मैं क्या करूं, मतलब मैं यहाँ हूं, यहाँ करूं, यहाँ पढ़ाऊं, ऐसे नहीं होगा ना यार. और बेसिक प्रोसेस है ना ये, तो मतलब दिस इज नॉट एक्सेप्टेबल यार. या तो मैं पहली बार कुछ बोल रहा हूं नई चीज. Now, so just a small text that Article 19 traverses its jurisprudential history back to the United States Bill of Rights and the First Amendment to US Constitution. The right is absolute under American jurisprudence. अमेरिका के अंदर जो फ्रीडम्स प्रोवाइड करी गई हैं वो एब्सोल्यूट है नेचर के अंदर. वहां पर स्टेट के पास बहुत लिमिटेड पावर्स हैं किसी भी सिटीजन की फ्रीडम्स को रिस्ट्रिक्ट करने की. Here it says the right is absolute under the American jurisprudence, limited only by the judicial creation of the policy power doctrine, police power doctrine. Whereas, but in India, reasonable restrictions are constitutionally prescribed itself under Articles 19(2) to 19(6). Dr. B.R. Ambedkar in the Constituent Assembly said that there can be no absolute rights and every right has to be abridged in some manner. Such restrictions are permissible in the light of Article 19 of the Article 29 of the Universal Declaration of the Human Rights as well. Now, what does the Supreme Court have to say? Supreme Court has laid down a test to determine whether restrictions that have been imposed on the exercise of the various freedoms is reasonable or not. Now, let's say there is a small fight that breaks out here on the street between 3-4 people. Now, in the interest of public order, can the state impose an internet ban on the entire country? It will be unreasonable. लड़ाई कहीं पे एक छोटी सी जगह पे हुई, आपने बोला कि नहीं इससे पब्लिक ऑर्डर डिस्टर्ब हो जाएगा पूरी कंट्री में, और आपने पूरी कंट्री के अंदर इंटरनेट बंद कर दिया. इट इज एन अनरीजनेबल रिस्ट्रिक्शन. फ्यू डेज बैक इन राजस्थान पटवारी का एग्जाम होना था. राजस्थान गवर्नमेंट बैंड दी इंटरनेट. उन्होंने इंटरनेट को बंद कर दिया उस दिन, राइट. फिर एक दिन टीचर्स का एग्जाम होना था, उन्होंने बोला कि चीटिंग होगी, फिर बंद कर दिया. See, these are unreasonable restrictions. Unfortunately, no one is questioning them also. We as citizens are just blindly sitting, concerned about many other important issues in the country, such as कि कौन से फिल्म स्टार के बेटे को कहां पे कौन से क्रूज पे पकड़ लिया गया 5 ग्राम ड्रग्स के साथ. That is what our priorities are. Our priorities are not about our own rights. Our priorities are कि भाई so and so X person, वो उसकी उससे शादी हो गई है कि नहीं हो गई है, कैटरीना की किससे शादी होने वाली है, right? This is what we are more worried about as a nation. So then that is what we are going to get in return. So anyway, the point is that in the cases of Chintaman Rao versus State of Madhya Pradesh and in Papasnam Labor Union versus Madurai Court Limited, the court has laid down certain considerations to understand whether restrictions are reasonable or not. The court states that, first, that the restrictions shall not be arbitrary in nature. There should be some objective criteria behind imposing restrictions. Up suddenly out of nowhere, out of thin air, you cannot impose restrictions on freedom that have been provided under Article 19. They should be having some logical basis. There should be some apprehension of danger. There should be some apprehension to public order. There should be some apprehension to security of state, sovereignty of India, whatever grounds have been provided. Merely just because you think that there should be a restriction, it cannot be the ground. There should be some logical basis for imposing restriction on any of the freedoms provided under Article 19. Otherwise, it would be considered as unreasonable. Arbitrary means unreasonable. So in Shreya Singhal case, court is saying that this inconvenience, annoyance, etc. are arbitrary in nature. इनका क्या basis है? आप किस basis के ऊपर ये law को apply करोगे? Inconvenience is a very subjective term. And annoyance is a very subjective term. You may not do anything, then also you may annoy me. Are you getting it? You're standing in front of me, you may annoy me. Just like that. Because I am annoyed. It's not because you are annoying me. So that it cannot be arbitrary, otherwise it will be called as unreasonable restriction. Secondly, the court also states that it should balance the individual rights and the social interest. See, various rights that have been provided under Article 19.1 from 19.1a to 19.1g are providing individual rights. Whereas 19.2 to 19.6 is trying to balance those individual rights with societal interest. Are you getting my point? भाई जो restrictions के grounds provide किए गए हैं वो individual की freedom को थोड़ा कम करके society के interest को promote कर रहा है. But the court states that both of them are very important. You cannot state that in the interest of societal interest, we will completely restrict an individual's freedom, then there will be no point of having the constitution in place. Third, the court states that such restrictions will be considered as reasonable only if they are imposed or sanctioned by law. या तो law directly वो restriction impose करे या law से वो restrictions flow करे. See, a lot of times rules are made by the government. So the court is basically saying कि अगर आप rules भी बना रहे हो freedom of speech and expression को restrict करने के लिए, freedom of movement को restrict करने के लिए, they should be sanctioned by some law. वो law के अंडर बनने चाहिए किस rules. You can't just make them suddenly out of nowhere without having any law in place. So when restrictions were imposed during COVID-19, they were made under the NDMA 2005 by issuing an order under NDMA 2005. But National Disaster Management is an act of the Parliament. तो कोई भी restriction जो आप impose करेंगे freedom के ऊपर वो law से sanction होनी चाहिए. वो executive का pure executive action नहीं हो सकता है. Even if executive is making rules that will have effect of law to restrict your freedom of speech and expression or any of the freedoms provided under Article 19, that should be in some way flowing from a legislation of the parliament or the state legislature. वो लॉ के अंदर होना चाहिए. सो जो इंटरनेट बैन लगता है, टेम्पररी सस्पेंशन ऑफ टेलीकॉम सर्विसेज रूल्स जो बनाए गए हैं, they have been made under the Indian Telegraph Act, and that is how internet can be suspended temporarily in certain areas. अगर गवर्नमेंट इंटरनेट को सस्पेंड करती without having any law also in place, then that would have been counted as unreasonable restriction. The idea behind this is because legislature ने जब लॉ बनाई होगी तो एक तरीके का चेक एंड बैलेंस ऑलरेडी आ चुका है उस सिस्टम में. executive, when it exercises powers, there may be one or two people who may be exercising that power. Possibility is there. But in case of legislature making a law, that is not a possibility, because legislature ने तो पूरा साथ में बैठ के law बनाई है. So the checks and balances are more in that case. And then the last thing that the court says is that they should be determined in an objective manner. Whatever restrictions that you are imposing should be determined very objectively. There should be some rational basis behind that. In addition to this, in Puttaswamy case, 2017 judgment of Supreme Court of India in right to privacy case, or what is also called as the Aadhaar case judgment, Supreme Court also lays down one more thing, that restriction will be considered as reasonable only if it is proportionate to the objective that it is trying to achieve. That is doctrine of proportionality. Court uses the term that you will not use a sledgehammer. आप कुल्हाड़ी नहीं use करोगे to kill a fly. Right? You will not be using a sledgehammer to kill a fly. Similarly, if there is a small riot that has broken out in some part of Delhi, it does not mean that you will impose a lockdown in the entire country. If there are some 5 cases that have come of COVID in Maharashtra, it does not mean that you will impose restrictions on the movement throughout the country. That will be disproportionate restriction on the freedom, and it will be therefore considered as unreasonable in nature. Is that understood to everyone? So the court has laid down a test of reasonability to determine whether the restrictions imposed are reasonable or not. And of course, court from time to time has expanded this test of reasonability. For example, as I told you, in Puttaswamy case, court has also laid down what is called as doctrine of proportionality to see whether the restriction that has been imposed on the freedom is reasonable or not. To see कि proportionate action लिया है कि नहीं लिया है. एक आदमी ने किसी आदमी को मार दिया, आप इसके बेसिस के ऊपर पूरी कंट्री के अंदर इमरजेंसी डिक्लेयर कर दो, या पूरी कंट्री के अंदर आप फ्रीडम ऑफ स्पीच एंड एक्सप्रेशन को रिस्ट्रिक्ट कर दो, और यू सस्पेंड द टेलीकॉम और इंटरनेट सर्विसेज थ्रू आउट द कंट्री. दैट इज unreasonable, disproportionate in nature. Is that clear? Right? So please just write down about reasonability of restrictions. Yes, sir. हो गया ये? हाँ? डॉक्ट्रिन ऑफ प्रोपोर्शनैलिटी कब डिस्कस किया? अच्छा, वो कर लिया, और टेस्ट ऑफ रीजनेबिलिटी भी कर लिया था हमने. ओके, ठीक है, ग्रेट. सो देन वी मूव ओवर फ्रॉम दिस doctrine of proportionality, and if doctrine of the entire reasonability and the meaning of reasonable restrictions has already been discussed. हाँ, क्या हुआ? हाँ, इससे लिख लेना. ये तो है, तो ये भी लिखा है, और सर ये भी लिखा है ना? तो ये आप प्लीज लिख लीजिए, मेरे को नहीं पता था, आई फॉरगॉट अबाउट इट. ओके, ठीक है. इज दिस डन? नाउ नेक्स्ट, आर्टिकल 20 ऑफ द कॉन्स्टिट्यूशन. बता दिया करो यार, मतलब सी आई हैव मल्टीपल बैचेस रनिंग, तो नहीं दिमाग में रहता है कि कौन से बैच में क्या कुछ हो गया है. ऑफ कोर्स ब्रॉडली आई रिमेंबर, बिकॉज दैट इज द फ्लो दैट वी हैव इन ऑल द बैचेस, बट at times there can be some variation. Okay, there is a possibility that may occur. Anyway, so Article 20 of the Indian Constitution. Now this is also a part of right to freedom provided to the Indian citizens under the Indian Constitution. And Article 19, Article 20, the heading of Article 20 is protection in respect of conviction for offense. So if a person is convicted for an offense, if a person is arrested for an offense, would that not be restricted that person's freedom? Yes. Yes. So किसी भी आदमी को जब अरेस्ट किया जाएगा या कन्विक्ट किया जाएगा और उसको इम्प्रिजन किया जाएगा, उसकी फ्रीडम रिस्ट्रिक्ट होगी. That basically means that this should also not be done in an unreasonable manner. There should be some safeguards related to the imprisonment of a person as well. There should be some safeguards that should be related to conviction of a person in cases of offenses. Because when you convict a person in an offense, you take away that person's freedom. So it is important that the state should not be convicting a person to restrict a person's freedom in an unreasonable manner. कुछ safeguards वहां पे भी होने चाहिए. So Article 20 is providing these safeguards in the Indian Constitution in case an individual is convicted for an offense. So what are these freedoms, what are these safeguards that have been provided? तो एक तरीके से अगर आप देखोगे ना, आर्टिकल 20 भी जो है वो एक नेगेटिवली वर्डेड आर्टिकल है. देखो, आपको और मेरे को पर से कोई राइट नहीं दे रहा है वो. बट अगेन द आइडिया बिहाइंड आर्टिकल 20 इज टू रिस्ट्रिक्ट द स्टेट. स्टेट को रिस्ट्रिक्ट करके आपको और मेरा राइट बन रहा है. राइट, दैट इज व्हाट वी नीड टू अंडरस्टैंड. सो आर्टिकल 20, there are 3 clauses in article 20 of the Indian Constitution. First one says that a person cannot be punished for a law, for an offense that was not an offense at the time of committing that act. Basically, if you do something today which is not an offense today, then 2 days later you cannot be punished for committing that act today which is not an offense today. Basically, आप retrospectively जाकर एक लॉ नहीं बना सकते हो और इंसान को retrospectively पनिश नहीं कर सकते हो. If on 26th of January 2010 it is not punishable to spit on the road, then on 28th of January 2010 state cannot make a law and say that any person who has spit on 26th of January 2010 will be punished for so and so offense. Because आप retrospectively past में जाकर एक किसी act को offense declare नहीं कर सकते हो. You cannot do that in case of criminal cases. So Article 20 clause 1 is about that. We will discuss about that. Then Article 20 clause 2 basically says that a person cannot be punished twice for the same offense. If you have committed murder, you will be punished once. You will not be given twice the punishment for the same offense that you have committed. See, of course, there is a difference between, let's say you committed murder and dacoity. Then you will be charged under 2 different sections. आपने दोनों offenses commit किए हैं, तो दोनों की punishment मिलेगी. पर आपको मर्डर के लिए ही 2 डबल पनिशमेंट नहीं मिल सकती, जिसको नॉर्मल टर्म्स में नो डबल जॉपर्डी भी बोला जाता है, बट वो गलत है, टेक्निकली करेक्ट नहीं है. बिकॉज डबल जॉपर्डी का मतलब थोड़ा और ज्यादा भी होता है, बट एनीवे, नो डबल जॉपर्डी. एंड द थर्ड वन इज दैट अ पर्सन कैन नॉट बी फोर्स्ड टू गिव एविडेंस अगेंस्ट हिमसेल्फ, और पर्सन कैन नॉट बी फोर्स्ड टू गिव टेस्टिमनी अगेंस्ट हिमसेल्फ. सो यू कैन नॉट फोर्स मी to say that I have committed a crime and then use that only as a proof or an evidence in the court to nail me down. That is something which is not allowed. Okay. So these are 3 protections that have been provided under Article 20 of the Indian Constitution. We will try to understand each one of them. So first is Article 20 clause 1. Article 20 clause 1 says that no person shall be convicted of any offense except for violation of a law in force at the time of commission of the act charged as an offense. So if at the time of committing that act, if that act was an offense, you can be punished for committing that act. But retrospectively, आप जाके किसी आदमी को एक पर्टिकुलर ऑफेंस एक्ट के लिए उसको ऑफेंस डिक्लेयर नहीं कर सकते. दिस इज ऑल्सो कॉल्ड एज द कॉन्सेप्ट ऑफ नो एक्स पोस्ट फैक्टो लॉ. no ex post facto law. That is, no legislation can be made that it's retrospectively going to declare you as a criminal. Otherwise, you can understand how this can be misused. Today, Parliament may pass a law to settle score with some people and may say that whoever has done this 10 years back would be punished for this particular offense. Right? So, that will be not reasonable. That will not be correct. हाँ, ये जरूर अलग बात है. देखिए, lot of times people say कि मुझसे गलती हो गई, मेरे को पता नहीं था कि ये करना अलाउड नहीं है. In law, ignorance of law is no defense. आप जाके किसी का मर्डर कर दो और आप बोलो कि मुझे नहीं पता था कि मर्डर करने का कोई पनिशमेंट मिलता है. मैं कैसे जान लूं तुम्हें पता था कि नहीं पता था? मैं ये मान के चलूंगा कि लॉ है, तुम्हें पता थी और तुम्हें ये नहीं करना था. राइट? सो कभी भी कोई पुलिस वाला आपको पकड़े तो ये मत बोलिएगा कि सर मुझे नहीं पता था कि ये क्राइम होता है. वो दे के दो धरेगा तुम्हारे कान के नीचे और बोलेगा कि अब पता चल गया क्राइम होता है. समझ रहे हो? सो नेवर एवर ट्राई टू टेक द डिफेंस दैट सर आई वॉज इग्नोरेंट, मुझे आई डेंट नो कि ट्रैफिक लाइट जंप नहीं करनी होती. राइट? नेवर डू दैट. इग्नोरेंस ऑफ लॉ इज नो डिफेंस इन लॉ. हाँ, ये जरूर बात है कि अगर उस समय लॉ ही नहीं है तो आपको उसके लिए पनिश नहीं किया जा सकता रेट्रोस्पेक्टिवली जाकर. नो रेट्रोस्पेक्टिव क्रिमिनल लेजिस्लेशन. Civil law can be made or civil penalty can be provided retrospectively also. The reason for that is Article 20 is saying no person shall be convicted of any offense for violation, convicted of any offense. Offense by its very nature here where we are talking about is criminal offense. तो इंडिया में क्रिमिनल लेजिस्लेशन रेट्रोस्पेक्टिवली आप नहीं बना सकते, बट आप सिविल लेजिस्लेशन जरूर रेट्रोस्पेक्टिवली अप्लाई कर सकते हो. राइट? सो नो पर्सन शैल बी कन्विक्टेड ऑफ एनी ऑफेंस एक्सेप्ट फॉर वायलेशन of a law in force at the time of the commission of the act charged as an offense. Not only that, a person can also not be provided a punishment greater than what existed at the time of committing an act that has been charged as an offense. So it says that nor be subjected to a penalty greater than that which might have been inflicted under the law in the force at the time of the commission of the offense. So if at the time of the commission of the offense, let's say on 26th of January 2010, the punishment for spitting was 3 months imprisonment, then you can't go back in past, let's say in 2020, and change the legislation and say that people, those who have committed this act, should be given 10 years punishment or 6 months punishment or 9 months punishment. That cannot be done. But do remember, ये कहता है कि आप greater punishment नहीं inflict कर सकते हो retrospectively. आप punishment को reduce जरूर कर सकते हो retrospectively. Retrospectively, you can change the law and provide for lesser punishment for an act or an offense. But you cannot provide a greater punishment for an offense retrospectively. But both these are applicable only in case of criminal legislation. In case of civil legislation, there is no such bar on the state to apply a civil legislation retrospectively. Is that clear? So this is first provision of Article 20, which is providing the freedom to the Indian citizens in a manner that they cannot be convicted and punished for an offense which was not an offense at the time of committing that act, Secondly, they cannot be provided a greater punishment than that existed at the time of committing that particular act. Is that clear? This is also called as the concept of no ex post facto law, or no retrospective criminal legislation can be made in India. ठीक है? Now, Article 20 Clause 2 of the Indian Constitution says that a person cannot be prosecuted as well as punished for the same offense more than once. It will be a travesty of justice if a person has been prosecuted and punished for committing an act already, then you again punish him for the same offense. But see, you committed one murder, you were prosecuted and punished, then you committed another murder, then of course that is another offense that you have committed. You committed rape and murder, you will be tried, prosecuted for rape separately and punished for that. You will be prosecuted for murder separately and punished for that. वो अलग बात है कि दोनों की punishment combine की जा सकती है, but आपको ये नहीं कि मर्डर के लिए 2 बार punishment देगा और रेप के लिए नहीं देगा. वो ये भी नहीं कह सकते आप कि नहीं, मैंने तो एक ही एक्ट कमिट किया था. You did not commit one act, you committed the act of rape as well as murder. So both of them are separate offenses and you will be tried for them separately and will be punished for them separately. इसको कई बार लोग बोलते हैं कि this is a concept of no double jeopardy as well, but वो गलत है. उसका रीजन ये है कि डबल जॉपर्डी का जो कॉन्सेप्ट है वो इससे थोड़ा ज्यादा होता है, दैट एग्जिस्ट इन यूनाइटेड स्टेट्स ऑफ अमेरिका. तो ये टेक्निकली यूज करना गलत होगा, बट बहुत सारी किताबों में, बहुत सारी जगह पे पीपल विल से दैट दिस इज द कॉन्सेप्ट ऑफ नो डबल जॉपर्डी, बट विच इज, एज आई एम सेइंग, बार बार बोल रहा हूं, टेक्निकली ये गलत है. कैसे है, क्यों नहीं है, वी विल नॉट गो इनटू दैट, बट इट इज नॉट प्रॉपरली, ये करेक्ट नहीं है. But see, now then the other question is, ki, let's say, and this was one case also that came up in the court. One person was found guilty by the department. एक डिपार्टमेंटल इंक्वायरी बैठी एक ऑफिसर के खिलाफ, and this person was found guilty in departmental inquiry for the act of corruption, for the offense of corruption. There was a departmental inquiry instituted against an officer. He was found guilty by the departmental inquiry and he was charged with corruption. And for this act of corruption, for this offense of corruption, the departmental inquiry recommended that this person should be suspended from service. He will be given suspension for a period of 2 years from the service. Let's say उसको 2 साल का suspension दे दिया गया सर्विस से. साथ ही साथ उसके खिलाफ एक और केस भी फाइल हो गया इसी करप्शन के केस में, एंड दैट वाज अंडर प्रिवेंशन ऑफ करप्शन एक्ट. एंड प्रिवेंशन ऑफ करप्शन एक्ट में उसके खिलाफ कोर्ट में ट्रायल चला, एंड देयर ऑल्सो दिस पर्सन वॉज डिक्लेयर्ड एज गिल्टी, एंड द कोर्ट सेड दैट अंडर प्रिवेंशन ऑफ करप्शन एक्ट दिस पर्सन विल बी सेंटेंस्ड टू 5 years ऑफ imprisonment. Now this person said that, sir, Indian Constitution Article 20 Clause 2 states that a person cannot be punished twice for the same offense. I committed an offense, I was punished by my department and I was suspended for 2 years. And now the court has also prosecuted me and tried me and punished me with 5 years imprisonment for the same offense of corruption, for the same act that I committed. Isn't this a violation of Article 20 Clause 2 of the Constitution? The court says no. Because the court says that the words that have been used in Article 20 Clause 2 are prosecuted and punished. And the court stated that prosecution can only happen in court. ये जो आपको डिपार्टमेंटल इंक्वायरी में सस्पेंड किया गया है, ये प्रोसिक्यूशन और पनिशमेंट नहीं है. अंडर द मीनिंग ऑफ आर्टिकल 20, डिपार्टमेंटल इंक्वायरी will not be considered as prosecution, and punishment given by departmental inquiry after departmental inquiry would not be considered as punishment under Article 20 Clause 2. Only the protection extends only in case of the fact that a person should not undergo a court trial twice for the same offense and should not be punished twice by the court for the same offense. तो आर्टिकल 20 क्लॉज 2 केवल और केवल कोर्ट के प्रोसिक्यूशन और कोर्ट की पनिशमेंट पे एक्सटेंड करता है. अगर डिपार्टमेंटल इंक्वायरी होगी किसी ऑफिसर के खिलाफ, दैट विल नॉट बी प्रोटेक्टेड अंडर आर्टिकल 20 क्लॉज 2. हो सकता है कि उस आदमी को डिपार्टमेंट एक अलग पनिशमेंट दे और कोर्ट एक अलग पनिशमेंट दे, क्योंकि डिपार्टमेंटल इंक्वायरी इज नॉट द प्रोसेस ऑफ प्रोसिक्यूशन एंड पनिशमेंट. प्रोसिक्यूशन केवल कोर्ट में किया जाता है. Then another question comes up in our mind when, let's say, trial court, subordinate court के अंदर हमारा मामला गया and a person was charged with, let's say, theft in trial court for an act of theft. उसको 6 महीने की सजा दे दी कोर्ट ने. अब वो आदमी उस डिसीजन के खिलाफ अपील करता है हाई कोर्ट में, और हाई कोर्ट में भी फिर वापस ट्रायल चलता है, और हाई कोर्ट भी उसको बोलती है कि नहीं, वी अपहोल्ड द पनिशमेंट प्रोवाइडेड बाय द लोअर कोर्ट दैट इज ऑफ 6 months. फिर वो सुप्रीम कोर्ट जाता है, सुप्रीम कोर्ट ऑल्सो प्रोसिक्यूशन हैपेंस एंड सुप्रीम कोर्ट ऑल्सो अपहोल्ड्स द पनिशमेंट. तो दिस पर्सन विल से दैट सर आई हैव बीन पनिश्ड थ्राइस. दैट इज रॉन्ग बिकॉज द प्रोसेस इज वन. फाइनल जो जजमेंट है, जब तक आपकी सारी लीगल रेमेडीज एग्जॉस्ट नहीं हो गई, तो वो एक ही प्रोसेस का पार्ट माना जाएगा. आप ये नहीं कह सकते कि मेरा 2 बार प्रोसिक्यूशन हो गया. 2 बार प्रोसिक्यूशन नहीं हुआ है, आपने उसी केस में अपील किया डिसीजन ऑफ द लोअर कोर्ट के खिलाफ इन द हायर कोर्ट, एंड इन द हायर कोर्ट डिसीजन यू अपील्ड इन द सुप्रीम कोर्ट. पनिशमेंट आपको एक ही बार मिलेगी. हो सकता है कि प्रोसेस ऑफ द ट्रायल ऑफ द कोर्ट हैपेंड मल्टीपल टाइम्स, बट दैट इज ऑल्सो वन प्रोसेस ओनली विच विल बी काउंटेड एज वन प्रोसिक्यूशन. सो यू कांट से दैट इफ the high court punishes me and upholds the punishment provided by the lower court, it will be considered as a violation of Article 20 Clause 2, because that is not the case. It is only one process that is going on. वो तो एक पूरा hierarchical process है. अपील किया है आपने लोअर कोर्ट के डिसीजन के खिलाफ, उसको आप फ्रेश पनिशमेंट या फ्रेश प्रोसिक्यूशन नहीं बोल सकते. Is that clear to everyone? This is 20 Clause 2 of the Indian Constitution, where a person cannot be punished twice for the same act or the offense that he has committed, cannot be prosecuted twice for the same act or the offense that he is charged of. And then we have Article 20 Clause 3 of the Constitution, where it says that a person who is an accused of any offense should not be compelled to be a witness against himself. एक आदमी को किसी पर्टिकुलर ऑफेंस में अगर वो अक्यूज्ड है, उसको फोर्स नहीं किया जा सकता अपने खिलाफ ही विटनेस बनने के लिए, टेस्टिमनी देने के लिए. There are some changes that have been introduced in the criminal law recently related to this, and there has been controversy over it. We will be discussing that in the current affairs classes, but for now let's just restrict to this basic provision. It says no person accused of any offense shall be compelled to be a witness against himself. So let's say you have been charged of murder, and the police comes and tells you that you give it in writing to us that you have committed the murder, or you accept it, and then we will use that as a testimony in the court. Not allowed. First and foremost, neither does Article 20 Clause 3 allow. The Constitution does not allow this to happen. Even जो Indian Evidence Act है, उसमें अगर आप सेल्फ टेस्टिमनी दोगे, एक्सेप्ट इन सम केसेस, इट विल नॉट बी कंसिडर्ड एज एडमिसिबल एविडेंस अगेंस्ट यू। जो आदमी खुद उस पर्टिकुलर केस में अपने ही खिलाफ टेस्टिमनी दे रहा है, ऑफ कोर्स दैट विल नॉट बी कंसिडर्ड एज एविडेंस इन दैट केस, ऑफ कोर्स, बिकॉज अगर आप आदमी की यह बात नहीं मान रहे हो कि भाई मैंने ऑफेंस कमिट नहीं किया है, तो आप ये कैसे मान सकते हो कि मैंने ऑफेंस कमिट किया है? यू गेटिंग द पॉइंट? एंड सी, देयर इज ऑफ कोर्स अ चांस that police or the executive agencies may try to torture an individual to accept some offense that he may or may not have committed. So therefore this is there. It basically is a principle which is also summarized as no self incrimination. Neither can you provide any oral testimony against yourself, nor are you supposed to provide any written testimony against yourself. But see, let's say police comes to your house and they say that you are accused of murder. We want to inspect your house. We have got the search warrant. And in that process, they try to take certain documents out of your possession. Can you deny to the police that I will not provide you so and so document, or I will not allow you to get this document, etc., because that will be an evidence against me, that will be in form of a witness against myself? No. अगर कोई डॉक्यूमेंट्री एविडेंस पुलिस आपकी पोजीशन से लेती है, तो ऑफ कोर्स इट विल नॉट बी कवर्ड अंडर 20। ये केवल ओरल और रिटन टेस्टिमनी के ऊपर एप्लीकेबल है। बेसिकली जो आप खुद बोलते हो या कहते हो अपने खिलाफ, वो अलाउड नहीं है टू बी यूज्ड एज अ टेस्टिमनी अगेंस्ट योरसेल्फ। ऑफ कोर्स अदर थिंग देन इज कि क्या फिंगरप्रिंट्स, थंब प्रिंट्स, इंप्रेशंस, हेयर फॉलिकल वगैरह लिए जा सकते हैं आदमी के डीएनए टेस्ट के लिए। लेट्स से देयर इज अ रेप केस एंड इन दैट द पुलिस वांट्स टू एग्जामिन एंड इन्वेस्टिगेट द सीमेन सैंपल ऑफ द अक्यूज्ड and try to match it with the semen sample that they have found on the body of the victim, then would that be counted as a protection under article 20 clause 3? No, because उसमें आप अपने दिमाग से कुछ नहीं कह रहे हो, वो तो फैक्ट है, that is a fact. Whether your DNA matches with that of the which has been found at the scene of the crime is a fact. इसको आप चेंज नहीं कर सकते हो। ये बात आप जरूर चेंज कर सकते हो कि मैंने मर्डर किया कि नहीं किया, ये आप कुछ भी बोल सकते हो। आपका जो फिंगरप्रिंट है वो फैक्ट है। सिग्नेचर स्पेसिमेन अगर आपको ऑब्टेन करती है पुलिस और बोलती है अपनी हैंडराइटिंग का स्पेसिमेन दीजिए हमें, हम मैच करना चाहते हैं उस हैंडराइटिंग के साथ जो यहां पे लिखी है, दैट इज अ फैक्ट, आप उसको चेंज नहीं कर सकते। सिमिलरली द क्वेश्चन देन केम अप कि जो नार्को एनालिसिस का टेस्ट होता है, आई होप यू नो व्हाट इज नार्को एनालिसिस, you know, lie detector test. A person is injected with certain drugs, etc. After that, the various electrodes, etc., are put on that person's body. Questions are put to that person in a subconscious state, and then on the basis of that, the police figures out that whether the person or the accused is lying or not. The court stated that narco analysis or this polygraph test that is performed on an individual is the right of an individual, whether that person wants to undergo that or not, and therefore it is not protected under, it is protected under article 20 clause 3. that is, अगर आप किसी आदमी के खिलाफ नार्को एनालिसिस करते हो तो ये उसकी मर्जी है, he cannot be compelled to be undergoing narco analysis, because आप उस आदमी की मेंटल प्रिवेसी को वायलेट कर रहे हो। You are entering into the mind of that person and trying to get an opinion out of that person's mind. That is not necessarily a fact. So the court stated that narco analysis cannot be compelled on any person. Polygraph test cannot be compelled on any person. A person can refuse to undergo polygraph test, but a person cannot refuse that मैं अपना blood sample नहीं दूंगा. A person, an accused cannot refuse that मैं अपना hair sample नहीं दूंगा. And an accused cannot refuse that I will not give my semen sample. That is something which will not be allowed, because that is not considered to be a testimony against oneself, but rather a fact against oneself. Is that clear? Right? So these are the three provisions. First one, no ex post facto legislation, criminal legislation. Second, no double jeopardy, to put it simply. And third, no self incrimination. Right? So please write down quickly related to Article 20 of the Constitution. Yes, please write down. Article 20 clause 1. Article 20 clause 1 prohibits retrospective effect prohibits retrospective effect prohibits retrospective effect of criminal legislation in India. Prohibits retrospective effect of criminal legislation in India. According to this provision, a person can be charged for an offense according to this provision, a person can be charged for an offense if he or she commits an act if he or she commits an act that is declared as an offense. If he or she commits an act that is declared as an offense at the time of committing the act. At the time of committing the act. Full stop. It is an important protection. It is an important protection as it saves the people. It is an important protection as it saves the people from instances of political vendetta. It is an important protection as it saves the people from instances of political vendetta where those in power may enact laws with retrospective effect to declare an act as an offense. Full stop. Further, this clause also prohibits greater punishment for an act. Prohibits greater punishment for an act in a retrospective manner. Full stop. In simple words, when a legislature declares an act to be an offense, in simple words, when a legislature declares an act to be an offense, it cannot apply the law retrospectively. It cannot apply the law retrospectively to prejudicially affect the individuals, to prejudicially affect the individuals who have committed such acts, who have committed such act, who have committed such act before the enactment of that law. Before the enactment of that law. Last line, full stop. On the other hand, comma, civil laws may be applied. Civil laws may be applied retrospectively in India. Civil laws may be applied retrospectively in India. ठीक है, हाँ जी. बहुत सारी लॉज होती हैं सिविल लेजिस्लेशन, बहुत सारे केसेस में टैक्सेशन मैटर्स के अंदर जो लॉज बनाई जाती हैं वो बहुत बार रेट्रोस्पेक्टिवली अप्लाई की जाती हैं. ठीक है. यस, नाउ प्लीज राइट डाउन आर्टिकल 20 क्लॉज 2. 20 क्लॉज 2. प्लीज राइट डाउन. दिस प्रोविजन प्रोहिबिट्स double punishment. This provision prohibits double punishment for the same offense. Full stop. It safeguards an individual. It safeguards an individual from facing multiple punishments. It safeguards an individual from facing multiple punishments or successive criminal proceedings. From facing multiple punishments or successive criminal proceedings for the same offense. For the same offense. Full stop. Although Article 20 Clause 2 disapproves double punishment, it does not provide immunity. It does not provide immunity in case of proceedings before a tribunal or a departmental inquiry. Tribunal or a departmental inquiry. Full stop. For example, a public servant who has been subjected to departmental proceedings. A public servant who has been subject to departmental proceedings and punishment may be punished by the court. For the same offense. May be punished by the court for the same offense separately. May be punished by the court for the same offense separately. और लास्ट इसमें लिख लीजिए, this clause does not prevent subsequent trials and conviction for another offense even if two offenses were committed, even if two offenses were committed at the same time. ठीक है, अब लिख लीजिए आर्टिकल 20 क्लॉज 3. आर्टिकल 20 क्लॉज 3. As per this provision, a person cannot be compelled to provide testimony. A person cannot be compelled to provide testimony against himself in a case where he is an accused. In a case where he is an accused. Full stop. In other words, a person is provided immunity. A person is provided immunity from self-incrimination. A person is provided immunity from self-incrimination. Full stop. The court has widened the meaning of the word witness. The court has widened the meaning of the word witness, and it includes both oral and documentary evidence. And it includes both oral and documentary evidence. For example, full stop, for example, a person may be asked to provide, for example, a person may be asked to provide an object or a document from his possession that is reasonably likely to support the prosecution. That is reasonably likely to support the prosecution against him. Full stop. It is for the same reason. It is for the same reason that the clause, that the provision, it is for the same reason that the provision does not bar medical examination. Does not bar medical examination of the accused. Does not bar medical examination of the accused or obtaining of thumb impression or specimen signature from him. फुल स्टॉप. इसमें आगे लिखिए इम्यूनिटी अंडर आर्टिकल 20 क्लॉज 3. Immunity under Article 20 Clause 3 is only limited to criminal proceedings. Is only limited to criminal proceedings. देखो एक चीज और ध्यान रखना कि आर्टिकल 20 की जो सारी प्रोटेक्शन है वो क्रिमिनल केसेस में ही क्यों इन्वॉल्व है, क्यों ही एप्लीकेबल है, क्योंकि केवल क्रिमिनल केस में ही एक आदमी को जेल दी जाती है और उसकी फ्रीडम को रिस्ट्रिक्ट किया जाता है. सिविल केस के अंदर एक आदमी को जेल नहीं किया जाता. इन सिविल केसेस अ पर्सन इज प्रोवाइडेड विद अ पनिशमेंट और अ फाइन इन फॉर्म ऑफ पेनल्टी, सम फाइन. not necessarily in form of imprisonment. तो आर्टिकल 20 जो है फ्रीडम की बात कर रहा है, आपकी फ्रीडम रिस्ट्रिक्ट नहीं होती है जब आपसे कोई फाइन या पनिशमेंट लिया जा रहा है. ठीक है, प्लीज राइट डाउन फर्दर. इन सेल्वी वर्सेस स्टेट ऑफ कर्नाटका, in Selvi versus State of Karnataka, the court held that a person cannot be compelled. The court held that a person cannot be compelled to undergo narco analysis. Cannot be compelled to undergo narco analysis as it violates a person's mental privacy. As it violates a person's mental privacy. ठीक है? So this is all about Article 20 of the Indian Constitution. No ex post facto legislation in criminal matters. Secondly, no double jeopardy. And thirdly, no self-incrimination against a person who is accused in that particular criminal offense. Yes, sir. सर, जो आप कोई भी अगर आप टेस्टिमनी अपने खिलाफ देंगे तो उसको एविडेंस के तौर पे एक्सेप्ट नहीं किया जाता है यूजुअली, एक्सेप्ट इन सम एक्सेप्शनल सर्कमस्टेंसेस. आप चाहे कोर्ट में भी विलिंगली भी बोल देंगे, क्योंकि वही बात है, जब मैं आपकी ये बात नहीं मान रहा हूं कि आपने क्राइम नहीं किया है, तो मैं आपकी कैसे बात मान लूं कि आपने क्राइम किया है. देयर मे बी अल्टीरियर मोटिव्स दैट यू मे हैव टू incriminate yourself. But see, there is a concept of plea bargaining also. There is a concept of pleading guilty also in the court. अगर आप किसी एक पर्टिकुलर ऑफेंस में अक्यूज्ड हैं और आप कोर्ट के सामने जाके बोल रहे हैं, हाँ जी मैंने ये ऑफेंस किया है, मुझे आप इसकी सजा दे दीजिए, मेरे को कोई दिक्कत नहीं है, आई वॉन्ट टू सेव द टाइम ऑफ द कोर्ट, then of course court will be sympathetic towards you because you are saving that entire proceeding of the court. The court may give you a lesser punishment. ठीक है, जिसको pleading guilty कहा जाता है. That you plead guilty and you say कि sir I have committed this crime but you please give me lesser punishment. I want to save the time of the court. क्यों? I don't want to take the court through that. Of course you can go and accept in front of a judge that I have committed so and so, but उसकी value जो है कोर्ट के अंदर कम रखी, उसको एविडेंस एक्ट में उसको सबसे पीछे रखा जाता है. Evidence Act keeps it in the lowest priority when you try to incriminate yourself, right? Of course, that can be used as a evidence against you. ऐसा बिल्कुल complete bar नहीं है. If you are doing it voluntarily, no issue. But will depend on the facts of the case, the guilt that is involved, what is the seriousness of the case, offense, so many other things. If it's a small offense, let's say of theft, then court will be willing to accept. If it's a case of murder where there may be multiple people who may be involved, then in that case there is a possibility that you are being compelled by someone else to accept your guilt in front of the court so as to save others. So there is a possibility that may be there. In that case court may not give enough credence to it. वो facts of the case के ऊपर case to case depend करता है. Indian Evidence Act वगैरह के matter में बात चली जाती है. ठीक है? Yes, any other questions? Okay, so we'll go into a break now. After the break, I will discuss Article 21 of the Indian Constitution with you, one of the most important provisions of India's Constitution, and also one provision where there has been a lot of judgments of the court and differing judgments of the court on the matter. Okay, I'll see you in a few minutes. Okay, so Article 21. Now, if there has been one article that has where there have been maximum judgments of the Supreme Court where it has tried to expand the meaning of a particular provision. That is Article 21 of the Indian Constitution. Now, first and foremost, Article 21 is applicable to both the citizens as well as the non-citizens, just like Article 20 of the Constitution as well. Article 21 of the Constitution, the language reads that no person shall be deprived of personal liberty and life except according to the procedure established by law. If I were to put it in very simple words, any person cannot be deprived, or no person's liberty, personal liberty or life can be taken away from that person without following the procedure that has been mentioned in the law. If you follow the procedure that has been mentioned in the law, then you can take away someone's life or personal liberty. For example, when death punishment is provided to an accused or a convict, that is an example of a person's life being taken away in accordance with the procedure provided by the law, as per the procedure mentioned in the law. So this is what Article 21 of the Indian Constitution states. ठीक है कि किसी भी आदमी की जान या पर्सनल लिबर्टी जो है उससे छीनी नहीं जा सकती, except in those circumstances where the law has provided a procedure for taking away a person's life or personal liberty, and that person's life or personal liberty is taken according to the procedure established by law. Now, what we need to keep in mind is that this is what Indian Constitution states, right? The American Constitution states that no person shall be deprived of his life, personal liberty or property except according to the due process of law. तो इंडियन कॉन्स्टिट्यूशन कहता है you can take away a person's life or personal liberty as per procedure established by law. अगर लॉ ने एक प्रोसीजर एस्टैब्लिश किया है और अगर आप उस प्रोसीजर को फॉलो करते हैं और उस प्रोसीजर से किसी आदमी की लाइफ और पर्सनल लिबर्टी उसको डिप्राइव करते हैं, देन दैट विल बी अलाउड. The American Constitution, on the other hand, is writing that a person's life or personal liberty or property cannot be taken away except according to the due process of law. So what is the difference between these two terms is what we first need to understand, and then we will understand that with the help of the case in the court as well, to what is the exact meaning of these two things. ये कह रहा है कि अगर किसी भी आदमी की जान या उसकी पर्सनल लिबर्टी लेनी है तो आपके लिए there should be first and foremost there should be a law. Law has to be there. That law should provide a procedure for taking away person's life or personal liberty, and the procedure should be followed. The process should be followed. This is the meaning of the term procedure established by law. अमेरिकन कॉन्स्टिट्यूशन में प्रोसीजर एस्टैब्लिश बाय लॉ नहीं लिखा है. सेम तरीके के वर्ड्स हैं, सेम तरीके का आर्टिकल है, इट्स अ सिमिलर आर्टिकल, बट इट डज नॉट मेंशन प्रोसीजर एस्टैब्लिश बाय लॉ, रादर इट मेंशंस ड्यू प्रोसेस ऑफ लॉ. Now, the concept of due process of law present in American Constitution states that there should be a law. The law should provide a procedure for taking away a person's life or personal liberty. The procedure should have been followed to take away a person's life or personal liberty, and उसमें वो एक और फोर्थ कंडीशन ऐड कर देता है. Due process of law is basically a step ahead of procedure established by law. A person's life or personal liberty cannot be taken away. First, these three conditions have to be satisfied if they have to be taken away. In addition to that, under due process of law, the law itself should be just, fair and reasonable. So under the concept of due process of law also, you can take away a person's life or personal liberty. But in addition to satisfying these three requirements, you need to satisfy the fourth requirement also, that the law should be just, fair and reasonable. Law should not be unfair, law should not be unjust, law should not be unreasonable. So one can say that due process of law as a concept is one step ahead of the concept of procedure established by law. यहां पे आपको ये तीन कंडीशन सेटिस्फाई करनी होंगी अगर आपको किसी भी आदमी की जान या पर्सनल लिबर्टी छीननी है तो उससे डिप्राइव, इफ यू वांट टू डिप्राइव अ पर्सन ऑफ लाइफ और पर्सनल लिबर्टी, दीज थ्री कंडीशंस आर नीडेड टू बी सेटिस्फाइड इन प्रोसीजर एस्टैब्लिश्ड बाय लॉ. बट इन केस ऑफ ड्यू प्रोसेस ऑफ लॉ, द सेफगार्ड इज even more. The safeguard is even more stringent. That is, the law itself should be just, fair and unreasonable. See, the reason for that is there is a possibility that the law made by the legislature may be unfair. That may take away a person's personal liberty or life. Let's say I make a law unreasonable. I make a law that any person who is found to be spitting on the road will be punished with capital punishment. Now, this is an unreasonable punishment that is made by the law. Concept of procedure established by law allows that to happen, because in that you don't need to satisfy the condition of the law itself being just, fair and reasonable. But in case of due process of law, the law also would have to pass the test of justness, fairness and reasonability. Only then can that law provide the procedure, and the procedure can take away a person's life or personal liberty. Is that understood to everyone? So यहां पे सेफगार्ड ज्यादा है ड्यू प्रोसेस ऑफ लॉ में, और प्रोसीजर एस्टैब्लिश्ड बाय लॉ में सेफगार्ड कम है. इसका मतलब ये है, अब देखिए, ये कहता है दैट अ पर्सन्स लाइफ और पर्सनल लिबर्टी कैन नॉट बी टेकन अवे एक्सेप्ट अकॉर्डिंग टू प्रोसीजर एस्टैब्लिश्ड बाय लॉ. इसके लिए एक लॉ होना जरूरी है. इट मीन्स दैट, और यहां पे लॉ का मतलब है लॉ इनैक्टेड बाय लेजिस्लेचर. इट डज नॉट मीन लॉ इनैक्टेड बाय एग्जीक्यूटिव. एग्जीक्यूटिव भी जो ऑर्डर्स बनाता है, नोटिफिकेशन बनाता है, हमने समझा है कि उसको भी लॉ बुलाया जा सकता है. बट यहां पे लॉ का मतलब है लॉ इनैक्टेड बाय लेजिस्लेचर, लॉ मेड बाय अ लेजिस्लेटिव बॉडी. सो बेसिकली अंडर दिस, अगर हम केवल इस कॉन्सेप्ट को पढ़ें, इट मीन्स दैट एग्जीक्यूटिव, इसका एक और मीनिंग है, एग्जीक्यूटिव कैन नॉट टेक एन एक्शन दैट इज नॉट सपोर्टेड बाय a law of the legislature to take away a person's life or personal liberty, because there is a possibility that the executive may try to misuse its powers. Because as I have told you again and again, executive के अंदर गवर्नमेंट में पॉसिबिलिटी ऑफ मिसयूज ऑफ पावर ज्यादा है, बिकॉज वहां पे 2-3 लोग भी डिसीजन ले सकते हैं. इन केस ऑफ लेजिस्लेचर दैट प्रोबेबिलिटी ऑफ मिसयूज इज लेसर. सो the safeguard that has been provided in the concept of procedure established by law is that executive cannot deprive you of your life and personal liberty unless the law is there in place. तो हम ये कह सकते हैं दैट प्रोसीजर एस्टैब्लिश्ड बाय लॉ एज अ कॉन्सेप्ट is imposing limitations on the executive. Can I say that? Yes, it imposes limitations on executive action. Imposes limitations on executive actions. But it does not impose limitations on legislative action, because legislature जो भी लॉ इनैक्ट करेगा, आप ये नहीं चेक कर सकते कि क्या वो लॉ फेयर है, रीजनेबल है, जस्ट है. अगर लेजिस्लेचर ने लॉ इनैक्ट कर दिया, इफ लेजिस्लेचर हैज इनैक्टेड अ लॉ and that provides a procedure to take away your life and personal liberty, and if that procedure is followed, no question can be raised, even if that law itself is unjust, unfair, unreasonable, does not matter. So procedure established by law as a concept imposes limitations on executive actions, but it does not impose any restriction on powers of the legislature. तो अगर लेजिस्लेचर ने लॉ बना दिया और अगर वो प्रोसीजर बता दिया और प्रोसीजर फॉलो हो गया, तो अ पर्सन्स लाइफ एंड पर्सनल लिबर्टी कैन बी टेकन अवे वेदर और नॉट द लॉ इटसेल्फ इज जस्ट फेयर और रीजनेबल. इज दैट क्लियर? दिस इज द कॉन्सेप्ट ऑफ प्रोसीजर एस्टैब्लिश्ड बाय लॉ. It's a narrower concept in a way as compared to the concept of due process of law, where you will not only check these three conditions, but you will also check this particular condition. Now, American Constitution has this, and Indian Constitution has this. इंडिया में हमने ये कॉन्सेप्ट कहां से अडॉप्ट किया? फ्रॉम यूके एंड जापान. बट सी, अमेरिकन कॉन्स्टिट्यूशन वॉज ऑलरेडी देयर इन प्लेस व्हेन वी वर राइटिंग आवर कॉन्स्टिट्यूशन. तो ऐसा तो नहीं होगा कि इंडियन कॉन्स्टिट्यूशन मेकर्स वर नॉट अवेयर ऑफ दिस. आर यू गेटिंग माय पॉइंट? व्हेन वी रोट आवर कॉन्स्टिट्यूशन इन 50, we knew that this concept also exists, but we chose this and not this. Why? To be very honest, if you look at the draft constitution of India, the draft constitution, जो पहला, जो constituent assembly में जाने से पहले भी जो draft constitution बनाया गया, the first draft actually contained these words only. Original draft of the Indian Constitution carried the words due process of law, just like the American Constitution. But a meeting happened of Sir B.N. Rao with some legal luminaries in America. And they told him and advised him that do not write due process of law, rather write procedure established by law. Why? They told him that, see, you are wanting to introduce various social reform legislations in your country. You want to introduce land reform laws. You want to abolish zamindari system, etc. and so forth. If you write this in your constitution, the courts will get the power to judge whether the law that has been made by the legislature is just, fair and reasonable or not, because under this concept, courts can impose limitations on the powers of the legislature also. In this concept, there are no limitations on the powers of the legislature. अगर आपने जमींदारी एबॉलिशन लॉ बनाया, आप क्या बोलोगे? That we are depriving a person of, let's say, his property. Okay. And the court will have no power to judge the legislation whether it is just, fair and reasonable. अगर आपके पास ये है, if you write procedure established by law, because the only thing that the court will try to satisfy is whether there is a law, है, whether the law provides the procedure, yes, whether the procedure has been followed or not. But if you end up writing the words due process of law, you will be giving extraordinary powers to the court to even examine a law made by the parliament or the legislature that may be depriving a person of his life or personal liberty, and your agenda of social reforms will fall flat on its face. So considering these things, B.N. Rao went back and said, no, let's replace this procedure established by law, due process of law, with procedure established by law. Ambedkar was against it. Ambedkar actually wanted the American concept of due process of law only to be there in the constitution, but then finally B.N. Rao had its way and he was able to get the procedure established by law written into Indian constitution. But this was of course going to create problems, because यहां दिक्कत है. अगर अब आप सोच के देखिए कॉन्ट्रडिक्शन कहां है. कॉन्स्टिट्यूशन में ही कॉन्ट्रडिक्शन है. आर्टिकल 19 ऑफ द इंडियन कॉन्स्टिट्यूशन स्टेट्स दैट योर फ्रीडम कैन बी रिस्ट्रिक्टेड बट ओनली इन अ रीजनेबल मैनर. जब आपकी पर्सनल लिबर्टी रिस्ट्रिक्ट हो रही है तो आप कह रहे हो कि वो अनरीजनेबल मैनर में भी हो सकती है. आप समझ रहे हो. अब पर्सनल लिबर्टी और फ्रीडम में फर्क तो ज्यादा है नहीं. Liberty and freedom as concepts do not necessarily have a lot of difference. I discussed with you earlier what is difference between liberty and freedom, but अगर आप देखो largely दोनों related concepts हैं. So Article 19 कह रहा है that a person's freedom cannot be taken away in an unreasonable manner. ठीक है. But Article 21 is saying that a person's personal liberty can be taken away in an unreasonable manner by an unreasonable law. Are you seeing the contradiction in the constitution itself? So somehow constitution makers miss this point, or even if they did not, they deliberately overlooked this, and they kept procedure established by law inspired by Japanese constitution, inspired by the UK concept कि कोर्ट्स के पास कोई पावर नहीं होगी. अगर लेजिस्लेचर ने लॉ इनैक्ट कर दिया तो कोर्ट बस इतना देखेगी लॉ है, लॉ ने प्रोसीजर प्रोवाइड किया है और प्रोसीजर फॉलो हुआ है कि नहीं. हमें क्या फर्क पड़ता है कि लॉ अनफेयर है, अनरीजनेबल है, अनजस्ट है. यहां पे कोर्ट के पास पावर है. सी इट कम्स फ्रॉम यूके ऑल्सो, बिकॉज इन यूके देयर इज द कॉन्सेप्ट ऑफ पार्लियामेंट्री सॉवरेनिटी. जो पार्लियामेंट कर देती है वो सही होता है यूके में. कोर्ट्स हैव वेरी लिमिटेड पावर्स इन यूके, अनलाइक इन यूएस और इन इंडिया. जुडिशियल रिव्यू की पावर्स बहुत कम है यूके में कोर्ट्स के पास. India may be adopted the concept of judicial review from United States of America. So there is an inherent contradiction in the Indian constitution between Article 19 and 21 if you look at it. Now a case came up in front of Supreme Court of India. This was one of the first cases that Supreme Court of India had to deal with after its constitution, and that case was A.K. Gopalan versus State of Madras. A.K. Gopalan was a communist leader, and it was alleged that this person is involved in several anti-India activities and is trying to foment trouble for the Indian government, etc. and so on and so forth. तो इनको preventive detention law में arrest कर लिया गया. Now what is preventive detention law? देखो दो तरीके की punishments मिल सकती हैं. दो तरीके के cases में आदमी को detain किया जा सकता है. Person can be detained under law in two ways. One, when you have committed a crime, or when you are accused of a crime. Almost the same thing, right? That is punitive detention. For having done something, or on the apprehension of having done something, you will be arrested and you will be imprisoned. This is called as punitive detention, as a punishment. On the other hand, there is preventive detention also. You can be arrested and detained without having done anything on the apprehension that you may commit a crime. Now, if you look at it, preventive detention is it's prone to misuse, है ना? Because आप किसी आदमी को अरेस्ट कर ले रहे हो, डिटेन कर रहे हो, ये बोल के कि तूने कुछ किया नहीं है, but तू कर सकता है, right? That is what preventive detention law is saying. So he was arrested under Preventive Detention Act of 1950 on the grounds that you may commit a crime. or you may cause public disorder. So he said that my personal liberty has been covered by this law. He went to the Supreme Court and stated that, sir, I have been arrested under Preventive Detention Act on the apprehension that I may commit something. My personal liberty has been restricted. And अब मैं जब इन लोगों को बोल रहा हूं कि give me an opportunity to make a representation against my arrest, that also they are not allowing me to do. He basically says, sir, this Preventive Detention Act under which I have been arrested is an unreasonable and an unfair law. And he says in the court that, sir, Constitution says that a person's life or personal liberty cannot be taken away except according to procedure established by law. And he says कि sir, केवल ये जरूरी नहीं है कि ये तीन कंडीशन सेटिस्फाई हो, बट द लॉ ऑल्सो शुड बी जस्ट फेयर एंड रीजनेबल. सो बेसिकली ही इज सेइंग कि इंडियन कॉन्स्टिट्यूशन में एक्सप्लिसिटली मेंशन नहीं है ड्यू प्रोसेस ऑफ लॉ, बट इट इज स्टिल देयर. Are you getting what I'm trying to say? He is saying that even though explicitly Indian constitution does not mention due process of law, but it is still there because the law that deprives a person of his life or personal liberty should be just, fair and reasonable also. ये law जो बात हो रही है, इसका मतलब केवल simply law enacted by legislature नहीं है. It does not mean a law simply enacted by legislature, but it also means a law that is just, fair and reasonable. And this law does not pass that test, and therefore you should hold that this law is unconstitutional, violative of my right under Article 21, and release me. See, the other thing which he also says is that, sir, when Article 19 is there and you say that restrictions can be imposed, they can be imposed on certain grounds. See, remember by that time 1950 में when he was making contention, reasonable word had not been introduced in Article 19. तब first constitutional amendment नहीं आया था. So he does not have the term reasonable to support his argument, but he says, sir, when under Article 19, let's say you restrict my freedom of movement, you will do it only on certain grounds. How can you restrict my personal liberty on any ground? Right? There is a contradiction, and you should reconcile these two provisions, and you should declare that this law is unjust, unfair, and unreasonable. The court did not agree with his contentions. The court gave the decision in the favor of the state. Court said that, see, we will only give a literal interpretation to what is mentioned in the Constitution, and procedure established by law means procedure established by law. It does not mean due process of law. In fact, the court goes on to give the argument on the basis of the Constituent Assembly debates also, where the court clearly states that if the constitution makers wanted due process of law, तो वो लिख देते. They have not written that it means procedure established by law. You cannot forcefully evoke due process of law by saying that Indian constitution should also imply that meaning as well. You cannot say that the law should be just, fair and reasonable. अगर ऐसा कॉन्स्टिट्यूशन मेकर्स को करना होता तो वो कॉन्स्टिट्यूशन में पर्पसफुली ड्यू प्रोसेस ऑफ लॉ लिख देते. They refer to the Constituent Assembly debates also, where in the Constituent Assembly debates, clearly some of the members of the drafting committee said that we have purposefully mentioned procedure established by law over due process of law. So judgment goes in favor of the state against A.K. Gopalan. इसका क्या मतलब है कि state or legislature can enact any law, even if that law is very unfair, even if that law does not give you an opportunity to make your point. भाई unjust law क्या होती है? जो कि principles of natural justice नहीं follow करती. One of the principles of natural justice is that a person should be given a right to fair hearing. A.K. Gopalan said, sir, I have not been given a right to fair. मेरे को मौका ही नहीं दिया बोलने का इन्होंने मेरे को बस अरेस्ट कर लिया. They are not allowing me to represent myself. But court says we cannot do anything. Sorry. This is what Constitution states. Court takes a very literal interpretation. See, you have to also understand, as I have told you time and again, whenever Parliament or executive will be strong, courts usually tend to be meek in nature. Courts usually tend to follow what the Parliament or the executive is doing. Look at, for example, the Shankari Prasad case. Court says कि हाँ ठीक है Parliament ने सही किया है. But the moment executive and legislature fall weak, court becomes strong. और ये हमेशा हुआ है हिस्ट्री में इंडिया की, हमेशा. If perhaps NJAC would have been introduced today, maybe court would have gone ahead with giving approval to NJAC, because the Parliament and the executive is very strong right now. Possibly, we don't know. But whenever Parliament and executive falls weak, court becomes strong. 67, Golaknath case. Court gave a very strong and an opposing judgment to its views given earlier. Why? Because they could see that the executive is crumbling. Congress party is falling apart. See, I'm not saying that that's how court functions necessarily, but this dynamic always plays a very important role. Now, this judgment of the court in A.K. Gopalan versus State of Madras in the case of 1950 continued to stand till 1978. Finally, when in 78, a case came up in front of Supreme Court of India, which was Maneka Gandhi versus Union of India. Now, what was the issue in that case? Maneka Gandhi wanted to travel abroad, but her passport was impounded by the regional passport officer. She made a representation to the regional passport officer asking, why have you impounded my passport? Regional passport officer says, we have done it in the interest of national security, national interest, etc. And we can't tell you what are the reasons. So now she again goes to the court. She says that, sir, when I am being restricted from going abroad, my personal liberty is being curbed. मेरी आजादी कर्ब हो रही है, मेरे को आप बाहर नहीं जाने दे रहे हो. और आपने मुझे राइट भी नहीं दिया कि मैं कुछ बोल सकूं. आपने मुझे बताया भी नहीं रीजन. ना तो आपने मुझे रीजन बताया or why I should not be allowed to go outside. Neither have you, nor have you told me or given me an opportunity to make my own representation or present my side of the story. You are depriving me of my personal liberty, of right to going abroad by an unreasonable law. And she again makes the same contention what was made by A.K. Gopalan in 1950. But this time she has support of Article 19 because reasonable restrictions has been introduced as a word. So she says that, sir, if you impose a restriction on my right to movement, that has to be reasonable. How can you say that you impose a restriction on my personal liberty and that can be unreasonable? This time, court agreed with the petitioner, who is Maneka Gandhi, and the court gave judgment in favor of Maneka Gandhi. And the court said that we agree with the petitioner that a law that deprives a person of his life and personal liberty should not only satisfy these three conditions, but it should also be just, fair and reasonable. Basically, court is implicitly introducing the concept of due process of law into the Indian Constitution. Of course, see, people will say it is controversial because जो चीज लिखी नहीं है और जो जानबूझ के नहीं लिखी है आप उसको इंटरप्रेट कर दे रहे हो. बट सी देयर इज अनदर थिंग ऑल्सो. ये भी तो है कि आर्टिकल 19 का टेक्स्ट भी तो पढ़िए और उन दोनों के बीच की कॉन्ट्राडिक्शन भी तो देखिए. एंड जस्ट बिकॉज लेजिस्लेचर पावर में है तो वो कुछ भी लॉ नहीं बना सकते. दैट इज अब्यूज ऑफ पावर. They can't be allowed to make any law which is unjust, unfair and unreasonable and take away a person's life or personal liberty. That will be wrong. So the court overturns the judgment of A.K. Gopalan in Menka Gandhi case, 28-year-old judgment, and says that from here onwards, courts will have the power to judge a law on this grounds as well if it takes away a person's life or personal liberty, because it is a very serious matter. So this is how Supreme Court evolved its view on the issue of procedure established by law and what does the meaning of the law. A.K. Gopalan court says law का मतलब केवल इतना है. But in Menka Gandhi case, court expands the meaning. And see again, why is this happening? Why is court suddenly becoming so activist? Government has become weak. Also, court has a lot of cleaning up of its image that it has to do, because the image of Supreme Court of India got severely tarnished during the emergency. It is often said that India's Supreme Court reached its lowest point in its functioning. Supreme Court of India reached its lowest nadir in its functioning during the emergency, because वो अपने सामने खुला violation of fundamental rights होते देख रहे थे and they did not do anything. Across the world, Indian Supreme Court and courts in India were criticized कि blatant violation हो रहा है आपके सामने फंडामेंटल राइट्स का, गवर्नमेंट कर रही है और आप आंखें बंद करके बैठे हैं. तो कोर्ट हैड अ लॉट ऑफ वर्क टू डू टू रेमेडी इट्स ओन इमेज, एंड दे सॉ दैट इन द as an opportunity in Menka Gandhi case to undo what had been done to their image during emergency. So Menka Gandhi case was a huge landmark case in the history of jurisprudence in India. Now, the other thing is that court also says that, see, Article 21 mentions no person shall be deprived of his life or personal liberty except according to procedure established by law. Court says life in Article 21 is a very broad concept. Life का मतलब ये नहीं है कि बस आदमी को जीने दिया जाए. If you deprive a person of anything which makes his life worthy of living, then also it will be considered as a violation of Article 21. So basically, court says life under Article 21 does not mean mere animal existence. कोर्ट कहती है कि जानवर भी जी रहे हैं, उनके पास भी right to life ही है. But क्या आप ये बोलोगे कि वो भी जी रहे हैं और हम भी जी रहे हैं? Can you equate? No. So the court then starts expanding the meaning of Article 21 and right to life. Life के meaning को धीरे धीरे multiple judgments में court ने expand किया. Court says that right to life also includes right to sleep. If you are being deprived of your right to sleep, except according to procedure established by law, then your Article 21 is getting violated. Right to life under Article 21 also means right to carry on your livelihood. It also means right to get educated. Because अगर आप education नहीं पा पा रहे हो तो क्या life जियोगे आप? It also means right to get shelter. It also means rights to get nutritional food. It means right to breathe the clean air. So अगर कोई भी ऐसी लॉ है या कोई भी ऐसा एक्शन है एग्जीक्यूटिव का या स्टेट का which is polluting the environment, which is degrading the environment, that is affecting your right to life, and you are being deprived of your right to life and not as per the procedure established by law. So court started to give multiple meanings to Article 21 and started to expand the meaning of the term life under Article 21. Plus पर्सनल लिबर्टी को भी कोर्ट एक्सपैंड करती है. इन अ रीसेंट जजमेंट, हाडिया केस, सुप्रीम कोर्ट सेज दैट राइट टू लाइफ एंड पर्सनल लिबर्टी also means right to choose your own life partner. You can go and choose whoever you want to be married to, and that right cannot be restricted in an unreasonable manner. It is your right to personal liberty. So by the definition of, by the judgment of Menka Gandhi, कोर्ट बिकेम एक्टिविस्ट इन नेचर एंड धीरे धीरे आर्टिकल 21 के मीनिंग को एक्सपैंड करना स्टार्ट किया. एक और चीज बोलती है कोर्ट, दैट इफ अ पर्सन इज डिनाइड राइट टू स्पीडी ट्रायल or a speedy trial is denied to a person, that is also depriving a person of his life and personal liberty in an unreasonable manner. You would have seen movie Ganga Jal, right? So क्या होता है गंगा जल में? what is the main crux of the story? Don't tell me कि अजय देवगन होता है, but right, I mean, what is the main crux? What is the main issue? One of the things which has been shown in Ganga Jal is that the case of Bhagalpur blindings. The police administration in Bihar was so fed up of criminals, where they realized that even if we catch criminals, they get away because they get bail, because they are very powerful, they are having political influence. So best है कि इन लोगों को जेल के अंदर ही अंधा कर दो. Pour acid into their eyes. गंगा जल. They call it गंगा जल. They say कि गंगा जल डाल दो इनकी आंखों में. Right? So the matter goes to the court. खत्री वर्सेस स्टेट ऑफ बिहार. स्टेट के ऊपर एक्यूजेशन ये लगता है कि आप लोगों की लाइफ छीन रहे हो, उनको अंधा करके, राइट टू लाइफ, विदाउट फॉलोइंग दी प्रोसीजर एस्टैब्लिश. कौन सी लॉ में लिखा है कि आप लोगों की आंखों में एसिड डाल दो जो अंडर ट्रायल्स हैं? कन्विक्ट भी नहीं है वो, देखिए, दे आर नॉट कन्विक्ट्स. नॉट दैट आई एम जस्टिफाइंग कि कन्विक्ट की आंखों में जाके गंगा जल डाल दो, ठीक है, बट आई एम सेइंग कि कन्विक्ट होता तो फिर भी 1% जस्टिफिकेशन तो है उसका कुछ. वो तो कन्विक्ट भी नहीं है, अक्यूज्ड है. सो द कोर्ट सेज दैट दिस अंडर ट्रायल प्रिजनर्स का टॉर्चर इज नॉट अलाउड. इट इज वायलेटिव ऑफ आर्टिकल 21. अनदर केस कम्स अप, हुसैन आरा खातून वर्सेस स्टेट ऑफ बिहार. The petitioner approached the court that there are so many people that are languishing in jails in India as under trial prisoners. Under trial वो आदमी होता है जिसके खिलाफ एक्यूजेशन है, वो जेल में है एक नॉन बेलेबल ऑफेंस में, बट वो प्रूव नहीं हुआ उसका गिल्ट अभी. बट क्योंकि आपका जुडिशियल सिस्टम इतना टाइम ले रहा है उनकी गिल्टी प्रोनाउंस करने में, वो लोग 3-3, 4-4, 5-5 साल जेल के अंदर बिता रहे हैं. While their trial is going on, they are being treated like criminals in jail. You are depriving a person of his life and personal liberty. Your procedure established by law should mean some reasonable time within which the case should be disposed of. आप अगर 10-10 साल लोगे केस को डिस्पोज ऑफ करने में, तो उस आदमी की क्या गलती है? So, Justice P.N. Bhagwati writes a judgment in Husain Ara Khatun case, and he says that Article 21 includes the right to fair and speedy trial, and if that is not followed, then we have the right to release the prisoners. And he makes an order. 40,000 prisoners across the country were released in one single go, those who were under trials, because he said that this is a violation of their Article 21. अगर 6 महीने से ज्यादा हो चुके हैं ट्रायल चलते हुए, 1 साल से ज्यादा हो चुका है, इनको आप बेल दीजिएगा, इनको छोड़िएगा, चलते रहने दीजिएगा केस, but they should be allowed to go out on bail. एक श्योरिटी ले लीजिए इनसे, बॉन्ड भरवा लीजिए, let them go. And if you find them convicted, if you find them guilty, fair enough, you put them back into prison, but till then let them be out, because this is violating their personal liberty and life in an unreasonable manner. So this is how Supreme Court, through its various judgments, has expanded the meaning of Article 21. Now see, of course, some people do not agree with the judgment of the court in Menka Gandhi and later on, but then, and they are correct also in some ways, because what is not there is not there, and purposefully not there, आपने उसको purposefully include कर दिया. But then the question is, that is that fair कि एक अनरीजनेबल लॉ बनाकर, अनफेयर लॉ बनाकर, किसी को अपॉर्चुनिटी भी नहीं दी जाए अपने आप को रिप्रेजेंट करने की, और उनकी फ्रीडम उनसे छीन ली जाए, पर्सनल लिबर्टी उनसे छीन ली जाए, स्पेशली व्हेन is also there. Now in this case, in Maneka Gandhi case, court also says one more thing, that three provisions of Indian constitution, three fundamental rights are forming the base, the trinity, the holy trinity of fundamental rights, 14, 19 and 21. Court says that if a person's life would be taken away as per the procedure established by law, or a liberty, personal liberty would be taken away of a person as per the procedure established by law, then that law should conform to standards of 14. That is, that law should follow the principles of natural justice, that law should be reasonable, that law should be not arbitrary. Remember article 14 में हमने ये समझा था ना, arbitrariness and equality are sworn enemies. And 14 में हमने ये भी समझा था implicit meaning of equality before law, और article 14 is also natural justice. And secondly, law should also follow reasonable restrictions. Law should be reasonable itself, that is taking away a person's life. So court कहती है कि 14, 19 और 21 म्यूचुअली एक्सक्लूसिव नहीं है, ये तीनों एक साथ पढ़ने चाहिए. जो लॉ आप 19 में बनाएंगे वो 21 के स्टैंडर्ड को फॉलो करने चाहिए और 14 को भी फॉलो करनी चाहिए. Whatever law you will make under 21 should also follow the 14 and 19 and so forth. AK Gopalan में केस ने कोर्ट ने ये एक्सेप्ट नहीं किया था. कोर्ट हैड सेड दैट दीज आर ऑल थ्री म्यूचुअली एक्सक्लूसिव, इनका एक दूसरे से क्या लेना देना. But in Maneka Gandhi case, court says that all three of them have been written in one part of the constitution. इन तीनों का बिल्कुल एक दूसरे से लेना देना है. They are all three related to each other. Is that clear to everyone? Right? Any questions still here? Yes, sir. बोलो बोलो. What is the current situation of? So see, we have, I don't know about what is the current situation of that Preventive Detention Act of 1950. उसके अंदर कुछ provisions have been struck down, some changes have been made. I think it continues to be enforced, but there are number of other preventive detention laws in India. And we will discuss about preventive detention laws in the next class when we will discuss 22. Because 22 is providing safeguards in case of punitive and preventive detention. इसका मतलब क्या है कि वो प्रिवेंटिव डिटेंशन को लेजिटिमाइज कर तो रहा ही है. एंड अंडर द इंडियन कॉन्स्टिट्यूशन ऑल्सो द यूनियन एंड द स्टेट्स अंडर द यूनियन लिस्ट एंड द कॉन्करेंट लिस्ट हैव बीन प्रोवाइडेड पावर्स टू मेक प्रिवेंटिव डिटेंशन लॉज. सो प्रिवेंटिव डिटेंशन लॉज आर वैलिड. नाउ वी विल डिस्कस अबाउट इट इन द नेक्स्ट क्लास दैट शुड प्रिवेंटिव डिटेंशन लॉज बी देयर इन अ डेमोक्रेसी और नॉट. बिकॉज दुनिया की बहुत कम डेमोक्रेसीज आपको मिलेंगी जहां पे प्रिवेंटिव डिटेंशन जैसी लॉज एग्जिस्ट करती है. बिकॉज देखिए, ड्रैकोनियन तो है ही ना. आप किसी भी आदमी को अरेस्ट कर रहे हो किस बात पे, कि आप कुछ कर सकते हो. हाउ डू यू जज कि कौन कुछ क्या कर सकता है? अनडेमोक्रेटिक तो है ही, इसमें कोई डाउट नहीं है. बट फिर इंडियन कॉन्स्टिट्यूशन, अब सी एक्चुअली पटेल से जब पूछा गया कि आपका क्या कहना है, आप तो बहुत डेमोक्रेसी फ्रीडम की बातें करते हो, आपने प्रिवेंटिव डिटेंशन लॉ लिख दिया है कॉन्स्टिट्यूशन में. ही सेड दैट विद अ हेवी हार्ट आई हैव टू पुट दिस इन द कॉन्स्टिट्यूशन, बिकॉज सिचुएशन ऐसी है कंट्री में इस समय दैट देयर आर पीपल दोज हु आर वांटिंग टू ब्रेक अपार्ट द कंट्री एट दिस पॉइंट ऑफ टाइम. There will be people, there are people those who are trying to cause riots across the country. There are people whom we know are trying to affect the unity of the country, and एक canny सा situation है. But what can I do? We had to put this in the Indian constitution as necessary evil. But my expectation is that we will not be forced to use these laws. हमें नहीं यूज करनी पड़ेंगी ये लॉज. बट ऐसा हुआ नहीं. देखिए, आज भी प्रिवेंटिव डिटेंशन लॉज को एग्जीक्यूटिव अक्रॉस द कंट्री मिसयूज करता है. Number of times they are misused. See, MISA, Maintenance of Internal Security Act, it was misused gravely by Indira Gandhi during emergency and before emergency. Right? Gravely misused by her. And the irony of the fact is that many of the leaders, those who fought against Indira Gandhi and those who were not happy with such law made by Indira Gandhi under which they had been arrested in cases of preventive detention, themselves today are misusing this law to arrest their political adversaries. This is also the reality, right? So ये irony ही है और कुछ नहीं कह सकते. Yes, any other questions? आई डेंट लाइक अंडरस्टैंड योर क्वेश्चन इन what फिर से बोलो क्या है, मैं आई डोंट. In what sense? So we will discuss about the relationship between DPSPs and fundamental rights later. But see, as far as, और उस पर डिटेल में हम बहुत डिस्कशन करेंगे जब हम DPSPs का चैप्टर आएगा. एंड कोर्ट ने क्या बोला है कि क्या DPSPs आर सब्जेक्ट टू फंडामेंटल राइट्स और आर फंडामेंटल राइट्स सब्जेक्ट टू DPSP. बट द प्रेजेंट स्टैंड ऑफ द कोर्ट ऑन रिलेशनशिप बिटवीन DPSPs एंड फंडामेंटल राइट्स, अगर मैं आपको नटशेल में अभी बोलूं और डिटेल में बाद में डिस्कस करेंगे, दैट इज both the provisions are constitutional provisions. No doubt fundamental rights are enforceable and DPSPs are not, but we should try to give effect to both of them in the maximum possible manner. उसको कहते हैं doctrine of harmonious construction. Actually doctrine of harmonious construction is a doctrine which basically states that if there are multiple interpretations of a legal provision, you should give that provision, that interpretation to that provision, so that it does not in any way make the other or renders the other provision completely useless. So yes, to an extent you can say that DPSPs are subject to the fundamental rights and even Article 21, but that's a complex situation and will be decided on the facts of the case. So it will be wrong for me to say कि क्या blanket में statement दे दूं तो गलत होगा. ठीक है? यार अब देखो, अब मतलब तुम अगर अचानक से अब तुम यूएपीए पे चले जाओगे, फिर कोऑपरेटिव्स पे ले जाओगे, सो देन आई विल ऑल्सो, मैं नहीं बता सकता करेक्ट या रॉन्ग. पहली बात तो आई डोंट नो दिस प्रोविजन. हाँ, मेरे को पढ़ना पड़ेगा डिटेल में. सो आई वुड से दैट आई एम इनकेपेबल राइट नाउ टू बी एबल टू कमेंट ऑन दैट. करेक्टनेस पे तो बिल्कुल ही incapable. Secondly, I don't even know this legal provision also. So for first I'll have to study that legal provision and then be able to comment on it. ठीक है? हाँ जी. When क्या, sorry नहीं ना, क्यों भाई? प्रिवेंटिव डिटेंशन लॉज आर स्टिल सब्जेक्ट टू दैट, दे शुड बी जस्ट, फेयर एंड रीजनेबल. ठीक है? हाँ जी. Due process of law is not same as judicial review, but one can say that due process of law is expanding the powers of judicial review. See, judicial review ना बहुत बड़ा कॉन्सेप्ट है. उसमें आर्टिकल 13 भी आता है. That is the power of the courts to judge whether a law is in conformity with fundamental rights. Judicial review में यह भी आता है that whether the law that has been made by the parliament or the legislature is conforming to the constitution, not just fundamental rights. Third is whether it is conforming to the basic structure of the constitution. And justness, fairness, and आप ये जरूर कह सकते हो कि हां, ड्यू प्रोसेस ऑफ लॉ या फिर ये जो इंटरप्रिटेशन कोर्ट ने दी है, दैट law should be just, fair and reasonable, expands the powers of judicial review. But to say that it is same as judicial review will be wrong. But does it give more powers to the court to judicially review a law? Of course, yes. It expands the ambit of the judicial review powers of the court. That is what I can say on that. ठीक है? Yes. Any other questions? नहीं, these are not laws. This is the expanded meaning of Article 21, where the court is saying that life under 21 means that you should also have shelter. हाँ, ठीक है. हाँ यार, अभी आपने क्वेश्चन पूछा, मैंने आपको बोला आपका क्वेश्चन गलत है, मैंने आपको क्वेश्चन को करेक्ट किया, आप फिर भी अपना वही सेम क्वेश्चन पूछोगे तो कैसे चलेगा? सर आप मेरी बात समझ लो ना पहले. आर्टिकल 21 में लाइफ के मतलब को एक्सपैंड किया गया है, शेल्टर उसके अंदर किया गया. अब दूसरी बात यह आती है, एनफोर्सेबल है कि नहीं है वो तो डिपेंड करता है सर, मैटर टू मैटर पे डिपेंड करेगा वो बात। देखिए आप ना बात जो है ना, आप बेसिक पॉइंट मिस कर जा रहे हो। जब भी मैं हर कॉन्स्टिट्यूशन के आर्टिकल में मैं आपको ये बोल रहा हूं, आर्टिकल 21 भी ना आपको और मेरे को कोई राइट नहीं दे रहा है सर। ये लोग गलत बात बोलते हैं कि आर्टिकल 21 इज राइट टू लाइफ, बेवकूफ है वो, क्योंकि उनको कॉन्स्टिट्यूशन की समझ नहीं है। राइट टू लाइफ जैसी कोई चीज है ही नहीं इंडियन कॉन्स्टिट्यूशन में। वो बस इतना कह रहा है कि आपकी लाइफ और पर्सनल लिबर्टी छीनी नहीं जा सकती एक्सेप्ट अकॉर्डिंग टू प्रोसीजर एस्टैब्लिश्ड बाय लॉ। तो इसका मतलब क्या है, राइट टू शेल्टर इज इंक्लूडेड इन 21 का मतलब यह है कि आपके राइट टू शेल्टर को छीना नहीं जा सकता एक्सेप्ट अकॉर्डिंग टू प्रोसीजर एस्टैब्लिश्ड बाय लॉ। इसका मतलब यह नहीं है कि आप जाके बोलोगे कि मेरे को शेल्टर दो, समझ रहे हो? तो ये दो चीजें अलग हैं। बार बार मैं यही समझा रहा हूं कि कोई भी फंडामेंटल राइट्स एक्सेप्ट 1 और 2 एक्चुअली पॉजिटिव है ही नहीं। वो उनका नेचर और उनका ऑब्जेक्टिव इज नॉट टू गिव यू एंड मी राइट्स पर से, इज टू रिस्ट्रिक्ट द पावर्स ऑफ द स्टेट एंड देन गिव अस राइट। दैट इज व्हाट आवर राइट इज। समझ गए? ठीक है, यस। What does that mean? And which magazine? Sir, if you randomly ask me that I read something somewhere, and then you please justify that I have not written that magazine, sir. Secondly, you have to tell me what is the exact source. But of course, if I don't want to join an association, it's my right? So I don't want to form an association. You can't force me to form an association. That is the point. हाँ, so see, again, ideally, basic understanding of this is that right to form associations, right to form unions, right to join cooperatives also means that you do not have the right to, you do have the right to not join them as well, right? But again, of course, see, अब ये फैक्ट टू फैक्ट पे डिपेंड करता है सर, केस टू केस पे डिपेंड करता है। ये मैं ऐसे ब्लैंकेट स्टेटमेंट दे दूं तो गलत होगा मेरे बिहाफ पे। ये आप जो कह रहे हो, आप एक बहुत स्पेसिफिक केस निकाल के ला रहे हो कि सर ऐसा केस हुआ, वहां पे एक चल रहा है इशू, तो वो तो फिर अब कोर्ट डिसाइड करेगी, और वो बहुत सारी चीजों पे डिपेंडेंट है सर, है ना? क्या कोर्ट में बोला गया, क्या नहीं बोला गया, एंड ऑल दोस थिंग्स आर आल्सो देयर। वन ऑनलाइन स्टूडेंट इज आल्सो आस्क्ड दैट डज राइट टू लाइफ इंक्लूड द राइट टू डाई? वी विल डिस्कस अबाउट दैट इन द नेक्स्ट क्लास, बिकॉज कोर्ट की इसके ऊपर भी कॉन्फ्लिक्टिंग जजमेंट्स रही हैं। अर्लियर कोर्ट सेड दैट भाई इफ राइट टू लाइफ इज देयर देन राइट टू डाई इज आल्सो देयर, बट लेटर ऑन court in Gyankor case reversed its judgment. It said that right to life does not mean right to die. Of course it does not mean मर रहा हूं तो मर ही रहा हूं ना, but you can't basically go and seek mercy killing, उसका मतलब ये है, ठीक है? और उसपे भी फिर कोर्ट का एक डिटेल्ड न्यूआंस्ड पर्सपेक्टिव है, we will discuss about it. Yes. Ma'am, again, DPSPs and fundamental rights, we will discuss the battle between two of them, and we will understand how court's perspective on this particular issue has evolved through its various judgments. Yes, any other questions? Sir, आप ना लॉ के स्टूडेंट हो, तो तुम काहे मतलब इतना, देखो, वेदर राइट टू वेदर ऑफिशियल सीक्रेट एक्ट, गाइज वेट 1 सेकेंड, वेदर ऑफिशियल सीक्रेट्स एक्ट फॉल्स अंडर द रिस्ट्रिक्शन और नॉट, इट शुड बी, अदरवाइज इट वुड नॉट बी देयर, एंड इफ यू थिंक अदरवाइज गो टू द कोर्ट। देखो यार, जो चीज है वो है ना। अब आप मुझसे पूछो कि सर क्या ऐसा है या नहीं है, ये तो सर आप मुझे 10 लाख रुपए दो, मैं चलता हूं आपके साथ कोर्ट, पिटिशन फाइल करता हूं, चलो हम चलते हैं दोनों कोर्ट में, अब ये कोर्ट से डिटरमाइन करवा लेते हैं, बट मैं क्यों टाइम वेस्ट करूं इस बात के ऊपर कि यार ऑफिशियल सीक्रेट एक्ट है कि नहीं, होगा ही तभी है, नहीं है तो जाके कोर्ट में प्रूफ करते हैं, चलो ठीक है। सी I appreciate the fact that you are trying to make your brain run in that direction, but ultimately you have to also understand कि हर क्वेश्चन का आंसर हम डिटरमिन नहीं कर सकते ऐसे, है ना, ब्लैंकेट इसको बिल्कुल एकदम सिंप्लिसिटी से लाके। गाइस 1 मिनट, एनी अदर क्वेश्चंस? हाँ, हाँ, सी पहली बात तो मैंने ये बोला कि राइट टू स्ट्राइक फंडामेंटल राइट है ही नहीं, वो एक स्टैट्यूटरी राइट है गिवन बाय अ स्टैट्यूट, इंडस्ट्रियल डिस्प्यूट्स एक्ट। तो हां, ये जरूर बात आ सकती है कि कोई बोले कि क्या उसमें वो इंप्लिसिट है कि नहीं है, नहीं है, बिकॉज वो फंडामेंटल राइट ही नहीं है, ठीक है। यस, एनी अदर क्वेश्चंस? हाँ गाइज 1 सेकेंड, you can say it violates 21. So good question, whether when tribal communities are relocated, displaced as a result of developmental projects, etc., would that be counted as violation of 21? Possibly yes. 19(1) E, yes, can be made as a contention, can be। See देखो अगेन, ये ना चीजें ऐसी हैं जो आप मुझसे पूछ रहे हो ना, आप मुझसे हाइपोथेटिकल सवाल पूछ रहे हो विदाउट फैक्ट्स ऑफ द केस, बट एट द सेम टाइम यस, कैन बी मेड। इज इट और नॉट मैं नहीं बता सकता हूं। देखो सर, मैं आपको ऐसा तो नहीं लग रहा ना कि मैं यहां पे चीफ जस्टिस हूं, तो मैं नहीं बता सकता, ये कोर्ट डिसाइड करेगी। बट हां, कुछ इंस्टेंसेस में समंथा जजमेंट ऑफ द सुप्रीम कोर्ट हैज सेड that tribals, those who are displaced due to developmental projects, if they are not rehabilitated, if they are not resettled, then we can call it as a violation of article 21। बट वो फैक्ट ऑफ द केस पे भी डिपेंड करेगा। आप कोर्ट में इसी को तो लेके जाओगे कि ये मेरे 21 का वायलेशन है, और यही पे तो कोर्ट में फाइट होगी कि क्या ये 21 का वायलेशन है कि नहीं है, क्या ये 19(1) का वायलेशन है कि नहीं है, राइट? दोज थिंग्स विल बी आस्क्ड इन द कोर्ट। So that is what we need to keep in mind. Any other questions? Okay, fine. Thank you so much. We have a class day after tomorrow, right? So I'll see you day after tomorrow. Thank you so much.